Bank of Africa, as strong as a group, as close as a partner.
Where Duraplas goes, water flows.
PS Industries has introduced a new roofing system known as ColorLink Plus.
Flamingo paint, simply superior. Syntax tank, are you strong? Are you tough?
Cherry Tree Properties. We develop spaces as though we were going to occupy them.
Good morning and welcome to Newsfile. This is your most authoritative news analysis platform, and here on Newsfile, as always, we put Ghana first. In my hand, the Handbook of Constitutional Law of Ghana and its History, Sir Akufo-Addo, and I'm reading from page 193, where he says that the superior courts consist of the Supreme Court, the Court of Appeal, and the High Court. In origin, it included the regional tribunals, which was a carryover from the public tribunal system established by the PNDC as a parallel system for the administration of criminal justice. These have been phased out. So, what's the fear about the revitalization of the public tribunals, regional and districts? The 50 million bail case, Eoco versus Dennis Miracles Aboagye, and the liberation of the Achimota forests, Galamsey, and change in mining laws all get our attention. The closed door for the Bank of Ghana governor, question of transparency being the casualty, and the bloodbath in the NPP's internal polls. Is the NPP in disarray, even in opposition? We're right back to deal with the vexed matters.
From the heart of Africa we stand, building dreams across the land. Every step we take your side, helping you rise, taking you higher. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a...
Palladium Residences in Achimota isn't just an address, it's the home you truly earned. Secure your place with just a 10% deposit and choose from beautifully designed modern apartments or spacious townhouses built for everyday comfort. This is more than a building. It's a vibrant, curated community with a clubhouse, state-of-the-art gym, and an on-site hotel, all at ABC Junction, minutes from Achimota Mall. Enjoy city energy while retreating to your private sanctuary. Call now to reserve your unit and benefit from limited launch incentives, including priority unit selection, executive pricing, and flexible payment options available. Don't miss the chance to pick the best homes. Book your private site visit today. Call 050-9823-424. Palladium Residences. Live smart, invest better.
Malaria's remedy is Lonat. Therefore, we're gonna use Lonat to recover. You have malaria?
Yes,
Are you shivering?
Yes, yes.
You got chills?
Yes,
Take Lonat.
Lonat.
First day.
Lonat.
Take Lonat. Second day.
Lonat.
Take Lonat.
Lonat.
Third day.
Lonat.
Take Lonat.
Lonat.
That's all. Lonat scatter malaria. Lonat scatter malaria.
This advert is FDA approved.
Hi, now let me share my wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up and in no time our tour began. We were surrounded by wildlife from the moment we entered the Eco Park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults? This price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It has been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
Upgrade your print game with Konica Minolta, proudly powered by SkySat Technologies. From all-in-one machines that print, scan, and copy to professional systems and heavy-duty production machines, we deliver unmatched performance. Right now, SkySat has an unbeatable offer. 1 entire year of free servicing on all Konica Minolta machines. That's 12 months of expert maintenance for new and existing customers. Visit our new VIP print center at Pegasus Place, Airport Residential Area for a live demonstration. Call us on 050-164-5180 or 0302-798-829. Again, it's 050-164-5180 or 0302-798-829. SkySat Technologies, performance that delivers every time.
You're welcome back. And here is Samson's take. Contempt of courts and the illusion of the truth defense. The core point of law in my take today, this morning, is that truth is not a defense when charged with contempt. Yes, I want my friends in the Inky fraternity to learn that. There is an ignorant, dangerous, persistent misconception within the media landscape that a journalist cannot be punished if they are merely reporting the facts or telling the truth. Let me bust your bubble. Let's educate ourselves. In the realm of contempt of court, specifically concerning the willful breach of an injunction order, truth is absolutely no defense. Yes, truth is your absolute defense in a defamation suit, but not in a contempt charge. This foundational legal principle, a long-standing global jurisprudence, was forcefully articulated by the Supreme Court in 1995 and has been followed over the years in the landmark case of Republic versus Mensah Bonsu. In her classic exposition, Her Ladyship Justice Joyce Bamford-Addo emphasized that the power to commit for contempt exists entirely to protect the administration of justice and maintain public confidence in the authority of the judiciary. Our 150-year-old Supreme Court has firmly established at various times a standard threefold test to succeed on a charge of contempt. That's civil contempt. The test requires proving beyond reasonable doubt that 1. There is a judgment or order requiring the contemnor to do or abstain from doing something. 2. The contemnor knows exactly what he is expected to do or abstain from doing. And 3. The contemnor failed to comply with the terms of the judgment or order, and his disobedience is willful. My dear friends, when a court issues an injunction restraining a party from making a specific publication, it is not a request for an opinion, nor is it an invitation to debate the veracity of the underlying facts. It is a strict judicial command, however wrong the judgment or order is in fact. And in this case, I don't really support that injunction order. But until a court has set a plain wrong judgment or order aside, you disobey it on the pain of potential jail, my friends. If a journalist chooses to publish the exact material prohibited by that order, the court is not called upon to determine whether the report is true or false. Please get that. The court is concerned strictly with compliance. To allow a party to intentionally violate a court order under the guise that the facts are true will destroy the rule of law, permitting individuals to try their cases in the court of public opinion and treat judicial directives as optional. Let's separate contempt from freedom of the press, my dear friends. Following the recent conviction of journalist Larry Allans-Dogbe of the Herald newspaper, who was sentenced to 7 days in prison for what the court determined as flagrant violation of an interlocutory injunction order, a problematic narrative began taking roots, started by him. He and several media practitioners attempted to shift focus to the factual accuracy of his reportage, arguing that the courts were actively attacking press freedom. Let the law be stated clearly once again. This case had absolutely nothing to do with an attack on press freedom. We must be candid with ourselves, or we lose integrity and faith with the people. Our Constitution guarantees free speech and media independence, but it does not grant journalists an absolute license or sovereign immunity to treat lawful orders of a court of competent jurisdiction with contempt. I've seen media people go to the defense of media guys who have been found doing wrong, even when they have been found acting rogue and fraudulently. We can't do that. Larry Dogbe was not convicted for being a journalist. No. He was sentenced to jail because the court found that he had verified knowledge of a restraining order and deliberately chose to publish headlines in direct defiance of it. While I express the view that a fine, a reprimand, caution, or a bond to be of good behavior would have been a preferable alternative to a custodial sentence, the same way I do when it comes to speech offenses, the trial judge, Justice Akufo-Addo, exercised a lawful judicial discretion. it was an option fully available to him under the law to protect the integrity of the court. Without my intervention to correct the facts and the law, this judge, the judiciary, and in fact government would have continued to suffer completely unwarranted public attacks over an engineered narrative of attack on press freedom. Now check the irony of judicial grace. The narrative of a vindictive judiciary becomes completely absurd when reviewing the official court processes immediately following the conviction. The very next day, the same judge who had been set up as a target for public outrage actually bent backwards to grant Larry Dogbe an unusual legal favor. On June 26, 2026, just the day after the conviction, Justice Akufo-Addo granted him interim bail pending appeal in the sum of 100,000 with 2 sureties, valid for a period of 10 days. In Ghanaian jurisprudence, this was an exceedingly rare, highly irregular occurrence because at the precise time the bail application was made and granted, a notice of appeal had yet to be filed. Typically, a legally filed notice of appeal is the absolute prerequisite and jurisdictional foundation for such an application. The court's order reveals that this bail was granted on the back of a motion ex parte, another irregularity, supported by an affidavit sworn by David Tamaklo, president of Prim Park. Here again, this judge did not insist that this route was not the acceptable standard in such situations. The strategy surrounding this maneuver quickly fell apart in the media. During that Saturday's Newsfile, Larry's lawyer, David Annan, asserted rightly that the bail application could not have been filed without first filing a notice of appeal. Guess what? The official court records explicitly expose this as a blatant falsehood. The official notice of appeal was not filed until July 6, 2026 at 12:05 p.m., a full 10 days after the bail application had already been moved and granted on the blind side of the plaintiff in the case who mounted the contempt application. So far from being a victim of judicial tyranny, the contemnor was the beneficiary of an extraordinary act of judicial leniency, with a judge willing to grant interim relief before the appellate framework was even properly invoked. Journalists, editors, and media houses must remember that they wield a powerful tool for informing the public, exacting accountability from official office holders and the public and for public education. But they are subject to the same laws as every other citizen. Freedom of expression does not mean freedom from compliance. And that is my take. Be right back with my guest.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number 1, let's bring baby girl. Let's bring. You did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? For quality and durability, insist on Syntex pipes. If you want quality, this be where you belong. Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex Vibe, it they carry water. No wahala. Syntex Vibe, it they make water they flow. Syntex, and you're strong, and you're tough.
In my line of work, a confident smile is everything. Kale Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kale Charcoal Toothpaste. Kale Charcoal Toothpaste. You're on a Kessie and in a kit one.
Samayo Kendini, a who be here, Semetra Sapapadia to a mammy manful. Kale Charcoal's natural ingredients, and a bomb is several by, a maniswing, Nesanso Mama Hotoso, a will bedroom.
Kale Charcoal Toothpaste.
Choose Kale Charcoal Toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kale, happy smile. This advert is FDA approved.
Discover Willow Lane.
To complement brushing, use a mouthwash daily to reduce harmful bacteria that cause bad breath, tooth decay, and plaque, which can lead to bleeding gums.
Rinse Fresh Go. For the maintenance of oral hygiene and healthy gums, you need Nesta Antiseptic Mouthwash with chlorhexidine digluconate. Effective for the treatment and prevention of bleeding or irritated gums, mouth ulcers, plaque, and bad breath. Rinse Fresh Go. Get the confidence and protection of long-lasting fresh breath with Nesta Antiseptic Mouthwash. Rinse Fresh Go. Available in original and fresh mint flavors. Manufactured and distributed by NS Chemist Limited. This advert is FDA approved.
Day by Day exists in lotion, cream, soap, and more. Day by Day has 4 fragrance range.
Welcome back. This is Newsfile. It's the most authoritative news analysis platform, and here on Newsfile, as always, we put Ghana first. And my guest, James Kobna-Bonfair, Dr. James Kobna-Bonfair Jr. is CEO of Census and lecturer at the UPSA. Victoria Bright, international corporate lawyer and entrepreneur. Dr. John Osai Kwapong, the Afrobarometer man, director, quality assurance and institutional effectiveness at Ashesi University and fellow with CDD Ghana. I was at Ashesi this week, and always it's such a pleasure to be with those students. They have very fertile minds in the things they talk about, particularly the law students. Nana, Eje Bafo, who are Vice Chair, Subsidiary Legislation Committee and Member, Constitutional and Legal Affairs Committee of Parliament. Theophilus Jamega Jr. is lawyer, engineer, member, National Communications Team of the National Democratic Congress. Ladies and gentlemen, good morning and welcome to Newsfile.
Good morning.
Good morning.
Thank you.
Right, so let's begin this way. We have to go to Eoco once again and ask a number of questions because they have come under some flack once again, particularly from the minority side or the NPP. But the same minority side and a cross-section of Ghanaians are not excited about the revitalization of the tribunals. What is the fear as far as the tribunal is concerned? Let's go to Parliament quickly and hear some of the things that happened there.
Foreign Affairs Minister was in the Volta region with the president, and I called him and he came back. There are some of our colleagues here who were in Yendi to attend the 3 days, Adua of our late King Diana. Because of you, I have brought all of them back. I can assure you that even if we will sit here till tomorrow morning, this bill will pass it today. We will pass it today. You can filibuster, you can do all the things that you want to do. I have your time. I have your time. We will pass this bill today. If he says they want to go ahead, and Mr. Speaker, when the majority leader speaks with all his authority, he says, today, he says he will pass. Mr. Speaker, the Constitutional Review Committee has spoken against this bill. They said they will do what they want to do. Mr. Speaker, we are Democrats. We are not going to be part of this Rambo style of Mr. Speaker destroying the judiciary.
Leader Alexander Penyumakin addressing an emergency.
Have left the chamber because the majority leader decided to shut the door. In Parliament, we believe that in all situations of disagreement, there must be a window to discuss, to raise the concerns. But once the majority leader makes a strong pronouncement that whatever the case, they will not listen, they will use their numbers to pass the bill, then there is no point again.
The judiciary every time comes to Parliament as part of the annual rituals with requests for more funding to do what? To establish more courts, to build more courthouses. And in order to justify that, they're able to give you statistics. Mm-hmm. So they tell you that they have about 10,000 cases pending before the circuit courts, maybe criminal cases under prosecution, civil cases, maybe about 15,000, district courts about 20,000, the high courts maybe 12,000. So the picture, and they give you all the statistics at the various tiers of the justice delivery system. So the picture that's painted to Parliament is that they are inundated with work. Mm. Okay, so what do? We thought through. Even in opposition, we're thinking that the CJ has the power to establish more courts and open more courts. But in opening courts, it became based on request and availability of resources. So when I qualified within the past 16 years, I believe that we have had like 35 more high courts established, in addition to the courts that we came to meet in 2009.
It's more than that.
35.
No, it's more. Are you looking at divisions of the courts?
Divisions of the high courts, that's what I mean. Okay. We have one high court, but opening them in some municipalities.
And then on the Akufo-Addo?
Yes.
We had over 100 courts being...
No.
So you're referring...
No, I mean the high courts, the divisions that have been created. Then, in Accra alone, the modern court complex, when we move from the fast-track court premises and the commercial court premises, and we move into the modern court complex alone contains 35 high courts. Financial courts, criminal court, land courts, matrimonial courts, and all that. 35. We started with 35. I don't know the numbers now. As for the circuit courts, plenty.
Right. So, Bafo, what's the fear? What's wrong with having public tribunals, regional and at the district level, to expand access to justice and to also give us speedy justice? Because in this case, what they have actually done is that you have done in Parliament, of course, you worked out, but it's still the product of Parliament, is that you have a 42-day timeline if somebody got involved in a Galamsey matter to be tried quickly and get done with. I don't know if that got an amendment to, I hear it may have gotten an amendment to 60 days or so. Why not? Why should we not do this?
Okay, so thank you very much, Samson. To start with, we are very blessed as a country. We are blessed because some of the things they intend introducing, we have experienced them before. And so we have the benefit of hindsight. And so we are in a position to say whether this will work or this will not work. And so we are not looking at the bill as presented in isolation. We are looking at it within the context of history, and then the context of our constitution, and the context of the statistics so far, particularly also because of the cases which jurisdiction have been assigned to this tribunal. And we're able to come to the conclusion that not only is the tribunal a mixed bag of unconstitutionality, right? It's not only a mixed bag of unconstitutionality, but a delayed prone mechanism and very expensive adventure, right? Which has failed historically and is not likely to make any difference. And I'm going to disintegrate or isolate the points made or the summary of it and then address you on them. The first point is that, Samson, look at the jurisdiction of the tribunal, the jurisdictions that the tribunals are supposed to possess. Mm-hmm. It tells you the cases that it's supposed to deal with.
Exactly.
If you look at the analysis of civil and criminal offenses for the year 2022-2023, and you go back, you realize that in terms of volume, there are some of the least cases the courts have been dealing with. And so if you propose to decongest the courts, really and truly, they should be the least of your worries, because they are not that significant.
Narcotics, income tax, customs, and minerals and mining, as in Galamsey matters and other things, right?
Yes. So if you look at the graph here, High Court criminal. This is the key. This is from the Judicial Service of Ghana, right? Now, where do you find them? You don't find them in any of them here, right? So let's see. attempts, abatement, criminal homicide and similar, criminal harm to the person, assault and similar offenses, kidnapping, abduction, sexual offenses, offenses involving dishonesty, forgery and similar offenses, unlawful damages, treasonable offenses, offenses against the peace, offenses against justice, public office and elections. And so it's the least in terms of volume. And so the data does not support the need to even set up a tribunal to deal with these cases. In terms of data, it doesn't even support it. Now, and so if we are talking about the need to decongest the courts, you will be looking at cases of high volume and giving them high attention. And you and I know that even the Chief Justice in exercising his or her special jurisdiction to create specialized courts will look at the volume of cases and decide that these cases, because of the high number of cases that we deal with, let me create a specialized court for them. And so if there aren't demand, the Chief Justice will not find the need to create specialized courts for a particular area of practice. And so right there, you realize that what they seek to do, it is not supported by data in terms of demand. In any event, Samson, we all know that when there has been an issue of congestion in our courts, it has had to do with lack of infrastructure. Our experience will show.
In 6 months,
pardon?
In 6 months, over 200 suspects have been picked up over Galamsey. You didn't take note of that?
In 6 months?
Yes.
Over 200?
Yes.
Good. Samson, we are looking at the existing courts, their ability to deal with specific cases, and the data showing a certain trend. If you pick 200 people within 6 months, that is not a trend. It's a recent occurrence. And so if you think that it is an important case, let the Chief Justice create a specialized court for you. A specialized division of the High Court.
That, in fact, has been done for Galamsey.
Good.
But the question of speed has come up. And in this case, they are saying, like we did for Supreme Court, where we used to do presidential election petitions for 8 months. We changed the rules, and we were able to do it within 45 days. So here, they say 42 days. I don't know if it's been shifted to about 60 days.
Samson, so let's take it step by step, and you appreciate that that indeed is not a solution. If you take the historical context, the tribunal is delayed prone, right? Cases in the tribunal delay more than the traditional courts, and there are historical records. The African Watch came to that conclusion. Human Rights Watch has come to that conclusion. Amnesty International came to that conclusion. In fact, the Constitutional Review Commission, the Fiajo Commission, following its consultation with the public, came to the conclusion that it should be abolished because it is of no positive use. Subsequently, all the Constitutional Review Committees that we have had have similarly recommended that it should be abolished. And so even what is on our statute book, there's the recommendation that it should be abolished. And so it does appear that the government, very respectfully, is alone. The NDC government is alone in terms of what it thinks of the tribunal. What has worked is the building of infrastructure, investment in technology to reduce congestion in our courts. And indeed, you and I know that in recent times, the building of courts in places like Adenta, the building of courts in places like Amasaman, the building of courts in Winneba, places where previously there were no high courts, places where previously there were no district courts, have proven to have reduced the congestion in our courts. And so if you think that there is the need to reduce congestion, the time-honored system or infrastructure has has proven to be more positive than the path that you are traveling.
And I confirm that through Justice Eni Yeboah, Sophia Akufo, there was an aggressive, court building process in all the places where you hardly have courts. So true, a lot of courts have been built.
And since the courts, since the government and the previous Chief Justice focused on the building of courts, we have also witnessed proper case management being pursued by our judges now. Today, when we first came to the bar, we all went to court at 9 o'clock. Today, judges give you time that come at 10 o'clock, come at 11 o'clock. And so case management...
Come at 8 o'clock.
Come at 8 o'clock.
We have courts that are doing 24-hour, as in the shift. Morning and afternoon.
So judges are now focusing on proper case management because we have now decentralized our courts, and so they are able to now say that we are going to employ such case management mechanisms to reduce congestion in our courts. And so what we require now is investment in technology and investment in further infrastructure. Why would you build a tribunal? In terms of cost, Samson, the tribunal system is twice expensive as the traditional courts. Let's look at this. Let's take the regional tribunal. The regional tribunal judge is of the same rank as a high court judge.
Correct.
And so you pay him the same remuneration and benefits as you pay the high court judge. The two panel members, assuming you are even going to pay them half of what you pay the chairman, right? That is going to be 50% each. And that would take the two to 100%. If you add it to the chairman, that is twice the cost of paying for a high court judge. They say they are going to build tribunals across the country. So that would be twice each high court in each region or each district, right? Why don't you rather focus on building more high courts? Since we have proven that when you have more high courts, when you have more district courts, when you have more circuit courts, congestion reduce in our courts. The rest of the money, which is the other costs of running the tribunal, invest them in technology. Now let's look at the rules of court. Let's revise our rules of court. Things like bail application, right? We shouldn't go to our courtroom to do bail application. Things like substituted service. We shouldn't go to our courtroom to do substituted service, right? Things like application for direction, right?
And some of the things Jay Bafo is talking about, elsewhere, a judge will pick a phone and call you, and you have a conversation, and the application is granted because you go to court and it will be granted anyway.
In England, England, for instance, barristers, right, agree on the issues. Right, there are pre-action protocols. You engage, there's a period, you engage, and then agree on all these issues so that the moment you have an agreement, you are ready to file your witness statement, and then you go for trial. And so really and truly, something, if you look at our Courts Act, for instance, it provides for masters who will sit on interim matters. We have not been able to implement all those. And so the tribunal is extremely unnecessary. Something, apart from it being extremely unnecessary, apart from it being extremely expensive, there's also the issue of constitutionality. What they are proposing to establish is not the same tribunal as provided for by our constitution. It is completely different. Our constitution is not envisaging a tribunal which is an independent body, as provided for by Section 4 of the Tribunals Bill, which is here to be assented to become an act. When you look at our Constitution, Article 126 of the Constitution, it provides for the Superior Court of Judicature, and it also provides for the lower courts, right? The Regional Tribunal is part of the Superior Court of Judicature, right? Here you are. When you look at Section 4 of the bill, it is proposing to set up a tribunal system. This is a system which was previously in existence under the PNDC, under the supervision of the Public Tribunal Board, which per the transitional provision of the Constitution was abolished within 6 months and integrated into the judicial system. Now you have a bill that says that isolate the regional tribunal from the Superior Court of Judicature. Because when you look at the bill, Samson, let me read for the benefit of your viewers. It says establishment of the tribunal system. Establishment of the tribunal system. So whereas we have a judiciary which is provided for under Article 125 of the Constitution, right? Established under Article 125 of the Constitution, okay? Now, this bill is proposing to establish a tribunal system. In furtherance of Clause 2 of Article 125, Clause 1 of Article 126, and Article 142 of the Constitution, that cannot be in furtherance of these provisions of the Constitution, because those provisions of the Constitution don't provide for a tribunal system. It provides for people's participation in the justice administration. But when you come to 126 of the Constitution, it tells you where the tribunals belong to. The tribunals do not form part of any tribunal system. It is part of our judicial system. But here we are. They are proposing to, there is established by this act, the tribunal system, which consists of a regional tribunal and a regional tribunal. So the regional tribunal, which is supposed to be part of the Superior Court of Judicature, right, similar in rank to the High Court of Justice, is now being isolated and being made part of a tribunal system.
Is it not semantic?
It's not semantic. When you read further, you see, when you interpret an act, you should interpret it as a whole. When you interpret this act as a whole, you come to realize that it's truly a parallel system. Now, when you look at...
When it was a parallel system, the appellate process was different. Now, the appellate process goes through the same court of appeal, not a different court of appeal, until if you reach the Supreme Court, so to speak.
Let me ask you,
why do you say it's still a parallel system?
Is Labour Commission part of our judicial system? Is Labour Commission part of our judicial system?
No.
But appeals from Labour matters from the Labour Commission goes to the Court of Appeal. Does it make it part of our judicial system? It doesn't make it part of our judicial system.
But you know that in its first original state, in 1979, it did not respect the normal court system. But now, it is through the normal court system.
I'm saying that if you say that because appeals go to the Court of Appeal, it is part of our court system, I'm saying that appeals from the Labour Commission goes to the Court of Appeal, but it doesn't make it part of our judicial system.
But that's different, because here, again, who superintends over these tribunals? In essence,
if you allow me, you come to appreciate that.
It is the Chief Justice.
Wait.
And then the Judicial Council, that also has a role in judges and judicial administration, also is part of this system, even though another oversight body has been set up.
I'm saying, hang on. You appreciate it better. They have set up, right? They have set up the twin brother or sister of the Ajikum Tribunal. That's what they have set up. You will see it. Come to the same section 4. It says that subject to the Constitution, this act and any other enactment, a tribunal shall operate as an independent body. Independent of who? Independent of what?
Courts are independent. Tribunal is independent.
So if a tribunal is independent, its independence is already, if a tribunal is part of the judicial system, its independence is already guaranteed under the Constitution. So independent of who? Independent of the courts.
But when you read the General Court Act, when it talks about the court, it speaks about the fact that the courts are independent, simply repeating what is in the Constitution. So what's wrong with that?
The Constitution talks about the judiciary being independent.
Correct.
I agree with you. But here, and in the Constitution, the tribunals that are part of the judicial system, okay, they form part of the judiciary and enjoys the independence that are guaranteed under Article 127 of the Constitution. But in this case, this tribunal, one, we have isolated the regional tribunal, which is part of the Superior Court of Judicature, and made it part of a tribunal system.
Okay.
Not a judicial system.
I will need you to be wrapping up in the next 3 minutes when you would have done 20 minutes so that I can go to somebody else.
The interruption made it difficult, but allow me 5 minutes to establish that it is a parallel system, and then we can move on. I beg you. Samson, come to section 5. The Judicial Council shall, in consultation with the Tribunal Oversight Committee, established under section 43, issue guidelines for the administration of a tribunal. So when you come to the Constitution, the Judicial Council, in so pretending over the judicial system, does not consult anybody. When you look at Article 127 of the 1992 Constitution, which guarantees the independence of our judiciary, this is what it says. In the exercise of the judicial power of Ghana, the judiciary in both its judicial and administrative functions, including financial administration, is subject only to this Constitution and shall not be subject to the control or direction of any person or authority. But here you are, in respect of the tribunal, the administration of the tribunal, the Judicial Council is now supposed to consult a Tribunal Oversight Committee. The Tribunal Oversight Committee is established by Parliament under Section 43 of this Act, of this bill. Now, guess what? It is established as a committee of the Judicial Council. When Parliament does not have the power to establish any such committee of the Judicial Council under Article 154, Clause 2. Let me read Article 154, Clause 2 for you.
That's serious.
The Rules of Court Committee, no, Article 154, Clause 2. The Judicial Council may establish such committees as it considers necessary, to which it shall refer matters relating to the judiciary. So the Judicial Council reserves the power to establish committees. Now Parliament has passed this law, right, saying that it has established a Tribunal Oversight Committee as a committee of the Judicial Council. Now, this Judicial Oversight Committee is the committee that the Judicial Council is supposed to consult in issuing guidelines for the administration of the tribunals. And you are telling me that is not a parallel system, my brother. It is a parallel system. It is not the tribunals as envisaged by Article 126, 125, and the others in the Constitution.
That's a very significant point, but we do not know what the final product is. Maybe these things have not found expression in the final product.
It found expression in the final product, my brother. These were the points which we were raising on the floor, and they said they will not listen. Right?
Are you sure they would not have listened to you if you were not just, a wholesale? Let's not have it.
My brother, we never on the floor of Parliament were doing the clause by clause review. And so we had gotten to clause 4. And we had raised the constitutionality of clause 4 as having established a parallel system. Right? And that we wanted to take a vote on it. We're engaging them, and they said no. And so they suspended Parliament for 5 hours, just so they could have the numbers to enable them pass it. My brother, so for 5 hours we were seated. And then the finance minister stopped, considering his economic and the economy and the finances of this country.
That's what has led to you sitting today, right? Today you're supposed to sit.
Yes. And they stopped everything. They called everybody from everywhere, and they came to Parliament, just so they can pass the clause 4. So when they realized that they had the numbers, then they said that night it will be passed.
Dole. Hold on. Theophilus, do you think that he raises some germane issues? Let's begin with you without constricting you to what he has raised. Why tribunals? Haven't we come too far? These have been phased out, as Professor Akufo-Addo will say in his very latest book.
First, it has not been phased out. It still remains on our Constitution and our statute books.
But they were phased out. We should admit that. It still remains in the Constitution, yes, but in practice,
operationalization,
it was phased out for decades.
Samson, in the NDC's 2024 manifesto, we made a promise to the Ghanaian people, which was the social contract we brought to the people, that if we are elected and voted into office, we will bring back the tribunal system. The Ghanaians overwhelmingly voted for NDC. So as part of the promise we made to the Ghanaians, we need to go back to our manifesto and make sure we go according to what we promised Ghanaians. So the idea that it was phased out, indeed, until I think Georgina Wood, CJ then, was not empaneling, post-1992, the tribunal systems were still working. We had, I think, the Yebi and Avalipo case that also went to the tribunal where
it was a challenge.
It was challenged, and the Supreme Court says that it can still try such a case.
That's so Dr. Obeda Samoa.
Obeda Samoa and Efadate challenging the jurisdiction of the the tribunal system there.
Right.
But if you also notice, the judges who were the heads of the persons who were the heads of the tribunals were appointed High Court judges. I think Justice Jakpasu and the rest were elevated to become High Court judges. I am a bit curious as to what my brother here said, particularly, I don't know whether to use clause or to use section now that it has been passed, section 43 of the Tribunals Bill, which says that in accordance with clause 2, which he read, there shall be an oversight committee. Let us look at the membership of the oversight committee. The membership of the oversight committee is one representative from the Judicial Council nominated by the Chief Justice, who is supposed to be the chairperson. One representative each of the following: Office of Attorney General, not below the rank of Principal State Attorney. One person from SHRAJ, organizations of lawyers, persons from organizations of lawyers with not less than 7 years standing as a lawyer nominated.
Organizations, Bar Association or Ghana.
So we have several.
Now
we have yes.
Yeah.
Now yes, we have more than one. I think the bill specifically tried to avoid a situation where they mention Ghana Bar Association. That's why
the bill is consistent with the Constitution Review Committee's report that says we should do away with mentioning specific associations in our Constitution and so on and so forth. Yeah.
One chief nominated by the National House of Chiefs, two persons who are not lawyers nominated by the Chief Justice, at least one of whom is a woman. The Chief Justice shall appoint the members of the committee. This is a strong safeguard to make sure that the committee that advises the Judicial Council in the tribunals, the operationalization of the tribunal, it's not anybody either political.
His point is that you are fettering the discretion of the Judicial Council by imposing on the Judicial Council an oversight committee when the Constitution gives the Judicial Council the discretion to set up committees. You have forced a committee on the Judicial Council.
It doesn't, but even though the Constitution says the Judicial Council may establish such committees as it considers necessary, it doesn't mean that the Act cannot have a committee and ask the Judicial Council to work with that committee. It does not. It does not preclude.
Do you agree with the arguments in the Supreme Court against the OSP's powers?
I agree.
You do?
Yes.
Do you find that this is almost the same?
No, I don't find this almost the same. In any case,
that the Attorney General has a discretion.
In any case,
to issue, as it were, warrants to people to do this thing, and they have by an OSP Act imposed a restriction, a fetter on the discretion of the Attorney General by giving that power to the OSP.
Okay.
If you support that, yes. you cannot support this argument.
I'll support. As I'm saying, that this one says that this has given a committee. It doesn't mean that by the constitutional provision that the Judicial Council shall form committee. Doesn't mean that an act cannot form a committee and ask the Judicial Council to work with that committee. It does not.
Okay.
Now, the idea about the OSP that you brought in, with all respect, let's wait for the Supreme Court's ruling. Perhaps I may support, but at the end of the day, we both might be wrong as to what the Supreme Court will come to. Now, Senior here mentioned the idea that if there are backlog of cases, one way is to expand the courts. Yes, the tribunal system has certain safeguards. Indeed, one of the things that the lawyer for Wontumi had been advocating is telecast, live broadcast of proceedings of court. This act or the bill has provided a safeguard that the proceedings at the regional tribunal may be telecast live if it involves very heavy or high public interest issues. So there's a safeguard. You see, their problem really has been the history of public tribunals. That is their problem. Now, all over the world, we still have
on the live telecast of proceedings.
On everything, the tribunal.
You know, it's not compulsory. It's not mandatory.
It's May. It's May.
So I'm going to ask you because we will get there when we get to Parliament and the issue of the Bank of Ghana governor. I hope you will not argue that way too. There is opportunity for it, because if it is May, it means the committee or the court can decide that will not broadcast, just like Parliament just said. It is a May, so they decided that the BOG governor will not do it, to the cameras.
When we get there,
I hear you.
We might have justifications to clear that. Now, the tribunal as it is, you just mentioned that there were 200 suspects of galamseyers arrested.
Only in 6 months.
In 6 months.
There have been several hundred before now.
And currently we have over 3,000 cases as backlog. Correct. And the Honorable Attorney General has said it over and over that there are persons you arrest today, they are granted bail tomorrow, and the next morning they are back into the pit and they are arrested again and brought back, and the system continues. We have made a pledge to the Ghanaian people to fight galamsey. And we said that this is one way for us to fight galamsey. The best is for you to join us to say, let us fight galamsey this way. You cannot just by saying, you said the 200 is a flip. It is not a trend. Now, if we go back, we will have data. He only gave the data for 6 months. If we go back, there will be data that will support this. Now, there is so much justification and public safeguard in the bill, such that the things of the past that had been there are no more going to be here today. If you look at the composition of the regional tribunal, go to section 18.
The composition does not really depart from the constitutional provision.
Yes, I think that the constitutional provisions were lifted almost verbatim into the Act. So there's nothing that has so much departed. If you read Article 142, which says that there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. A regional tribunal shall consist of the Chief Justice, one chairman, such members who may or may not be lawyers. If you come back here, it's the same thing that is in the bill. There is no departure. So the idea that there is a parallel system, it's not a parallel system. It is just what the Constitution has asked to be done. And the NDC has promised Ghanaians that when we are elected, we are going to bring back and get this to clear backlog of cases. There are cases that last over 5 years. And the specific cases, as he said, narcotics, income tax, galamsey, and customs, these are the areas that are specifically carved out for the regional tribunals to deal with. Now, in order to avoid situations where there will be political interference, etc., it says that the appointments shall be in consultation with the Judicial Council. All these safeguards have been made. So I do not see where Council's fear and apprehension is about this case. He has brought, sorry, you brought the data about the backlog of cases that has been dealt with. So the tribunals as it is at the moment, the bill as it is at the moment and passed, is going to create a situation where there will be expeditious trial of cases. Now, the idea of us having the regional tribunal, Jekum type of tribunal that existed in 1982 to maybe 1990 will not be there, because the safeguards here are stronger than what was in there.
Do you think those guardrails are sufficient? Because as he speaks, they may be a bit permissive and things may happen, but you are still making your
okay, Samson,
submission.
The things about you raised the issue about the OSP and just oppose it with Article 142 as he said here.
Right.
Now, if that becomes an issue and the bill is passed and assented to, you go to the Supreme Court and challenge its validity to see if that is it. If the Supreme Court agrees with you that that is unconstitutional, it will be struck out, and that part will be. Now, the guardrails that have been put in place are such that they are supposed to ensure fairness, transparency, expedition, and efficiency in our judicial system. Now, if we are going to establish more courts, it's the same thing as establishing more tribunals. Now, we are saying that the power of the legislature, the judiciary, is a power that emanates from the people. So we are saying, let us bring that back to the people. Let people be part of the judiciary system such that some of the myth around the judiciary will be removed. It says that citizens may exercise popular participation in the administration of justice through institutions of public and customary tribunals and the jury and assessor system. That is why we say that, okay, if we have a tribunal system, panelists must not necessarily be members of the judiciary or must not be lawyers, but ordinary members that will be able to administer justice in the name of the people. Now, we have the jury system. Even recently in the UK, they tried to do away with the jury system. The lawyers were against it. The Deputy Prime Minister and the Minister for Justice, he was so much vocal about removing the jury system, but the lawyers were against it, and the jury system is still back in the UK. The problem here, or the issue here, is that you are supposed to be tried by your peers. So
Can I ask you a small question?
Yes, I'm with you.
What I hold in my hand here is the white paper report of the Constitution Review Commission of Inquiry, June 2012. Please, you know who was president June 2012?
Professor Mills. Professor Mills.
Okay. So you remember that Professor Mills set up the Constitution Review Commission.
Yes.
Professor Akufo-Addo, who brought this document to us. You know that in this document, they have spoken to thousands of Ghanaians, including judges and everybody else. And they came to the conclusion that the tribunal system should be done away with that. You know that. Now, this is the white paper. This is what it says. Page 20. Maintenance of regional tribunals in the court structure. Government accepts the recommendation that regional tribunals be abolished and matters handled by them incorporated into the regular court schedule. Government, however, holds the view that the chairman or the chairman of the regional tribunals, if any, should be absorbed into the judiciary as high court judges. How do you reconcile this with this position now?
You see, something, as at 2012, the issues that we are talking about to be handled by the tribunal system were not prevalent then. The issues of galamsey, narcotics, etc. were not prevalent then. We are talking about the exigencies of the system today and the demands of justice and the pledge we have made to the Ghanaian people that we are going to deal with galamsey and narcotics. So if the issues of galamsey and the backlogs were as high then as it was in 2012, I believe that the government's white paper would have been different. But currently we are saying that the issues we have today call for a different system. And the traditional courts are not able to handle the number of cases we have expeditiously. So let us have a system. Already it is in the Constitution. So let us just activate it and get those things up to run together with the court system. So it is not 2012, we are in 2026 today.
Right.
Good.
In 2025, this president set up the Professor H. Kwesi Prempeh Committee, Constitution Review Committee. This is the report, full report. And this report at page 282, recommendation. The committee recommends that regional tribunals be de-established from the Constitution. The committee notes that the High Court has been handling the caseload of regional tribunals. The resources to be committed to resuscitating the moribund regional tribunals could be channeled to resource the High Court, as well as the circuit and district courts that the committee now proposes to make part of the regular judiciary. Moreover, the jurisdiction of the circuit courts could be expanded to take on some of the cases that the regional tribunals would ordinarily hear. Is this sound or not sound?
Something that is a recommendation that the government.
My question is this sound or is not sound?
It is sound to the extent that it is a recommendation.
Okay.
It is not yet sound to the extent that the government has not commented on what it needs to do with the recommendations of the Constitutional Review Committee.
Okay.
So as long as we wait for the government to issue its white paper on this current Constitutional Review Committee, this is what the government has proposed and is dealing with the issues that have been identified in there.
Professor Akufo-Addo and his team, they spoke to thousands of Ghanaians. Professor H. Kwesi Prempeh and his team, they did equal, but not as close to this one. Does it mean that you guys don't respect the views of Ghanaians?
You agree with me that the original constitution, they spoke with thousands of people before the tribunals found its way in the constitution. It doesn't mean then that they disrespected Ghanaians. No, they spoke with them, and that was what culminated in this. Indeed, they even spoke to any person of any walk of life, to the extent market women, carpenters, lawyers, everybody that found its way into this. Now, the Professor HKP Prempeh's issue, as I indicated, this is yet to be commented on by the government. And indeed, I think last week or a week or 2 weeks ago, the Minister for Communication made a statement that very soon this has been debated, I think, or commented on in cabinet. So that will be talked on. So to the extent that the government has not come out on what its position will be in Professor H.K. Prempeh's recommendations, I think that we are done with the tribunal bill. And as it is, that is the position of the government at the moment. It doesn't in any way negate the fact that the recommendations, they have spoken to Ghanaians, and that is the government disrespect Ghanaians. No, far from that. However, it doesn't also mean that everything contained in that document will be what the government will accept. Indeed, there are certain things in there that yourself you disagree with, that we shouldn't come up with. The Council of State already has even raised concern in certain things. So it is not about everything that is in that document that the government will be accepting.
I appeared before them, and I was unhappy about the delays in our court. And I felt like happens in other jurisdictions, they could put timelines. So I'm happy to see timelines with the tribunals.
Yes.
In the Supreme Court rules, you know, I was the consultant for the rules that led to the, less than 45 days of hearings. But my question to Vicky, and perhaps also to the democratic integrity person, the two of you, is it okay for our executives, as in the executive arm of government, to do the things they do, that they set up commissions and committees, they consult with all of us, and they say, the people of Ghana say, this is what we want, and then they decide to cherry pick? Is that not a subversion of the collective will? Yes, Vicky.
Well, democracy is supposed to be government of the people, by the people, for the people, right? So if you put it that way, I guess the short answer is yes. That's how the populace will see it. I mean, this whole issue with tribunals, it's very complex. Although I believe that there has to be some constitutional, we should approach it with constitutional openness. I think there should also be historical caution. Because the question for me is whether the system that this bill is proposed by the bill is necessary. Is it necessary? Is it properly designed? And is it sufficiently protected from political interference and abuse? These are the core questions. There is a historical burden, and government cannot ignore the fact that the word tribunal, that word, carries a very complex and deeply troubling history in our country. We all saw, or some of us who are old enough anyway, saw public tribunals at the time, and they were widely associated with political persecution, weakened procedural safeguards, and violations of fundamental rights. The bill does acknowledge this history, I have to say, and it does attempt to distinguish the new tribunals which are being proposed here from those of the past. It places the new ones within the judicial structure, subjects them to our 1992 Constitution and the laws of evidence and criminal procedure, and guarantees legal representation, etc., etc. These are important safeguards. They are. But when all is said and done, public confidence will depend less on the language that we're all reading, because we're very good at putting beautiful, languages and things in all our statutes and etc. And the focus will be more on, one, how appointments, two, prosecutions, and three, proceedings operate in practice. The proposed regional tribunals will have concurrent jurisdiction with the High Court, as we've heard, over serious criminal matters, these narcotics, tax customs, mining offenses, etc. The district tribunals will exercise concurrent criminal jurisdiction with the circuit courts. So these are not merely informal or community-based dispute resolution bodies. They will exercise substantial judicial power, impose criminal sentences, and potentially deprive citizens of their liberty. So for me, there's a fundamental question that is raised, is raised in my mind. If the tribunals will apply the same criminal procedure, the same evidence acts that we all know, and possess substantially the same powers as the High Court and the Circuit Court, why are new tribunals required rather than additional specialized divisions of the existing courts? So government needs to demonstrate that these tribunals will solve a clearly defined institutional problem rather than merely create another layer within an already very complex judicial system. That is what I believe.
Are you convinced that this is a necessary layer?
Well, I mean, the devil is in the detail. I mean, as things stand, I would have preferred that government went the other way and strengthened what we already had. That said, when it comes to matters like Galamsey, I can see the need for speed, extreme speed.
So change the rules.
As is being proposed.
Change the rules. Exactly. That's what they are saying. Don't set up new courts.
Specialized courts or rules can be set up to deal with that.
In fact, as we speak, the CDD has also been working on a document. I worked on the first paper, which they put before the Chief Justice, before this Chief Justice, asking for, say, parliamentary election petitions for the timelines to be shortened, just like we have done for the Supreme Court as well.
Yes.
So the argument is that the rules can be done. Why do you set up a new system?
Well, this is it, Samson. And also, one thing that troubles me is the risk of forum shopping. Because the bill gives the tribunals jurisdiction that overlaps with the High Court and the Circuit.
Concurrent.
As I said earlier. And it provides that where both the court and tribunal have jurisdiction, the tribunal may proceed unless the Chief Justice determines otherwise.
Right.
So for me, this creates a real danger of selective prosecution and forum shopping. And because a prosecutor can choose whether an accused person is tried before our conventional courts or before a tribunal which is exercising similar powers. There's no clear objective criteria for deciding which cases go to the tribunals and which will remain before the ordinary courts. And I don't think that discretion must be left entirely to prosecutors.
Apart from the bit of omnibus, provision for the jurisdiction, which says that they will deal with fraud and matters involving the state, I thought the rest of the cases they can do has been clearly outlined. Tax, customs, narcotics, they have stated them.
Under the Constitution, the court has jurisdiction in all matters.
Yes.
And Parliament cannot
concurrent jurisdiction, please.
But I'm saying hold on. Jurisdiction in all matters. And so even if certain jurisdiction has been assigned to the regional tribunal, you cannot say that because it's been assigned to the regional tribunal, the High Court doesn't have jurisdiction.
Nobody has said so. The law says
so now
what has been passed says both can have that power.
What she's saying is now justified. Then the prosecutor will decide whether to take the person to the High Court or the regional tribunal.
So this is the way you smuggle yourself into presenting a new
Thank you very much, Vicky,
yes, Vicky,
for allowing me to assist.
That's okay. No problem. So for me, these are some of the problems. You know, there are some issues that we have to.
But the guardrails.
And there are guardrails.
Correct.
There are guardrails, and I like those. For example, the fact that the Evidence Act will be applied. That to me is important. And the criminal procedure rules will be applied. There will be open trials. That is an important
which can be
guardrail. Yes, there's legal representation and legal aid.
That's right.
That's also important. Proceedings are recorded, and there's appellate review. So, and formal judicial oversight. And it will be integrated into the formal judicial system. So these are the guardrails.
But non-judges can outvote a judge.
In fact, you took the words right out of my mouth, because there are two of them. There are two of them. And there's the legal person who...
It's not actually giving that there will be two.
Yeah.
In the old law, Act 459, the Courts Act, it was provided that it will be the chairman, not less than 2 and not more than 4.
Yes.
Now, what they have done is not less than 2.
Less than 2.
So it's not guaranteed that it will be just 2.
It will be just 2.
Right.
Exactly. So if it's 3 and 1, even if it's 2 and 1, unless one of the lay persons decides to support the legal person who actually understands the issues, that's it.
Who actually understands the law,
the legal issues.
Because
yes. Let me rephrase that. Of course. Otherwise, they won't be sitting there.
Right.
Yeah.
Like the jury system, the judge will be the trier of law, and the juror or the other members will be the trier of facts.
Of the facts.
So how can we raise this? Is this tenable to raise this? Because we still do the jury system, where you have a juror and one judge.
Yes, exactly. So, I mean, I think, to me, the success of this bill, well, before I even say that, 3 questions that government needs to answer in wrapping up. Number 1, what specific failure in our existing court system requires the creation of the tribunals? That's the first question. Well, I think we need to go beyond that. Number 2.
Roxanne says source of employment.
I'm not going to comment on that. Number 2, what objective criteria will determine whether the case is sent to a tribunal rather than this is what the point I was making. And number 3, the protections that will prevent the tribunals from becoming instruments of selective prosecution or political control. When all is said and done, the success of the bill will not be measured on how quickly tribunals convict people. I don't think that's what will determine its success, but on whether they deliver justice independently, fairly, and without reviving the abuses that made them so feared in our history.
Dr. Osayi-Kwapong.
So, thank you, Samson, and good morning to everyone else. The issue of the executive, right, setting up these committees, commissions, and seeming to appear to exercise some kind of veto over that. I'm still waiting to see what the government's position would look like on the recommendations and how we proceed. How we proceed in terms of if the government comes out and says that Professor H. Kwesi Prempeh made 128 recommendations, we accept 50, we reject the rest. Does it mean that only the 50 they accept would be subjected to the subsequent...
Of course.
Yes.
Of course.
If that is the case, right, then I would find that unfortunate, because the executive is only one stakeholder among all the democratic stakeholders.
Except so that you note that on this case, they say they are not issuing a white paper. Whatever is issued will now come to decide what the effect is.
Right, but I think for me, there are all of these other stakeholders within the democracy ecosystem, you know, academics, researchers, civil society, citizens, you name it all. So whilst they are entitled to issue their whatever they want to call it, that, you know, we like these recommendations, we don't like these recommendations, I'll be curious to see whether the effect of that would mean it is only the ones that they quote unquote like or agree with is what then would move to the implementation.
They have just passed a tribunals law,
right,
against what the recommendation is, against the recommendation they had accepted earlier. So,
and you see, if you do that, the next time around that you set up this kind of commission and you expect citizens to invest time and energy in giving feedback, it would create a counter effect, which is, well, the executive will do what it wants to do anyway, so what's the point? And so tying that to this tribunal issue, the four quick things I had in mind was, and you just brought the first one up, it seems as though it is a preemption of what the Constitutional Review Commission is saying, right? That do away with these tribunals. So why don't we wait to see what happens to that recommendation, unless the the action taken by Parliament is to preempt that, to say this is not a recommendation that we are not going to go with. Tied to that is the activation of it now, because this constitutional provision has been there since 1992. So I'm just curious as to why now, right? That if we've lived through 3 decades of this constitution, you know, why now? Madam Vicky had already mentioned the issue of the concurrent jurisdictions and the forum shopping. What I had written last night was that, does it create a perverse incentive, you know, for your prosecutors to try and figure out where do I take which case, and unless
the discretion belongs to the prosecutor,
right? Unless
they deal with the criminal cases, they decide where they go.
Precisely, and unless maybe in the implementation guidelines that you still put some firmer rules around it that would guide the exercise of that jurisdiction.
Implementation guidelines for law cannot depart from what the law is. So if the law says this is what it is,
and that's what it is.
You can't pass, you know, a legislative instrument or whatever guidelines that would depart from the law.
So then that becomes a worry in terms of, you know, where do I take this particular case, and would you be shopping for a place where you would think would be friendly to the prosecutor? The last thing I would add is, so what, I was only 7 during the 81 revolution, but the memories I have of the word tribunal is not positive, right? So there's this bedding also to try and shift the public perception of this idea of a tribunal to quote unquote something positive. So there's also that challenge that when you hear the word tribunal, even if the bill is intended to try and do some good things, you know, case management, speedy delivery of justice, etc., etc., that historical bedding still weighs on those who are advocating for the establishment.
Has what has been passed not completely take us away from the past? And I've done a 3-part series of articles on this, and I've started sharing them on my Facebook, where you can go and check them out. I don't make judgments. I've just visited Justice S.A. Brobe, very authoritative on trial courts and tribunals in Ghana, and then Professor Akufo-Addo's book, and then I've used other authorities to make a discussion. The initial era, 1979, when the Armed Forces Revolutionary Council set up the Special Courts Decree, of course, they took over power, and they realized that if they have to go with the normal court, they won't get what they want. That's how come we began with the tribunals. Let's set up our own. So it was completely parallel. It was characterized by severe public opacity, fear, and executive finality. The national attitude was one of helplessness against summary justice, as the operations of those bodies bypass all traditional safeguards of fair trial and standard evidentiary rules. In S.A. Brobe's book, he says, quote, "Not much was known of the special courts or who actually sat to try cases there. The operations and procedures of these courts were also shrouded in mystery, but people were known to have been fined, imprisoned, executed, or had their properties confiscated by others from those courts." What we have is a shift. There is actually opportunity to broadcast it live. There is an oversight mechanism for it.
I understand all of that, and we talked about even some of the guardrails that have been built into it, an oversight committee and all of that. But shaking off certain historical burdens doesn't only come with putting in certain guardrails. It is the effect you give to those guardrails that would eventually convince citizens that this is a complete departure from the past. And
in those days, when they give a decision, it's not subject to appeal. Now, if they give a decision, it's subject to appeal to the Court of Appeal.
Thompson, I agree with all of that. All I'm saying is that that historical burden would not simply go away with the insertion of guardrails in the legislation. It is the effect we give to those guardrails when this bill is assented to and it comes alive. I think that is what eventually would shake off some of, at least for someone like me, who also had family that had to face these tribunals, would say, yes, we have completely departed from the past.
Yeah. I'm coming to Dr. James Bonf, but hold on just a second. Dennis Ejejumo, a lawyer who has also worked around this, done some review of this bill in this state, not after it has been passed, joins us for the next just about 2, 3, 5 minutes to share an insight about an aspect that is both constitutionally and legally problematic. Thank you, Dennis Ejejumo, for joining us. Hello, Dennis. Dennis, please unmute your mic.
Is it better now?
Great, you are clear. Great. Tell us about your major concern about this bill.
Okay, so thanks, Samson. One of my major concerns, and I think we have reached a stage where the executive have resolved that it will pass the bill.
They have passed it anyway.
It has passed it. So our duty, as academics and as policy people, is to try and raise certain concerns that we think, and which, if they have taken their time to listen to other voices, maybe have been corrected. Now, one of the major issues that the government has a bigger problem of governance and politics, where we have a government with white paper as far back as 2012, where the government, headed by the President of the Republic, accepted to abolish the tribunal system in its white paper. Okay, all the Commission of Inquiry done by Professor Akufo-Addo to Clara Kasati's committee, to H. Kwesi Prempeh committee, all recommended for its abolishment. Okay, and the government at that time, headed by the President, and at that time to Honorable Ayini, happened to the Deputy Attorney General, and it's a white paper I believe they all concurred to, and they agreed to that. But because they have now made it a political statement, and I realize the NDC member said that it was in their manifesto, it now becomes a checklist for what they have to do, and they have passed it so as to satisfy the requirement of their manifesto. So on a political question, they might have satisfied it, but on the governance question, their white people accepted the abolishment. So we move from there. Now, one of the major things is that the tribunal system has also gone through our court, including the Supreme Court. I've realized that people mention the case of Yebi and Abalifo. Now, one of the things that everybody fails to mention is that the proviso of concurrent jurisdiction of the High Court being given to the regional tribunal has been ruled in Yebi and Abalifo as unconstitutional. And so if you look at Act 459 and you look at the current provision, it's more like it's in pari materia. It was a repetition of it, but the drafters might have left out the part of the decision of Yebi and Abalifo, which related to, interestingly, NDC's money being stolen and people being taken. They pay attention to the second part of the judgment, but the first part of the judgment, where the court struck out the parliament giving concurrent jurisdiction of the court. So first I asked myself, if that law had been ruled as unconstitutional as far back as 2000, why should the drafters
let me read what their Lord said in Yebia Navalifo.
Yes.
They said, in our opinion, therefore, Section 24(1) of Act 459, the Courts Act, which you just referred to, which vests in the regional tribunal concurrent original jurisdiction in all criminal matters with the High Court, is clearly inconsistent with the letter and spirit of the Constitution 1992. And by Article 1(2) thereof, same is null and void. It follows that on a true and proper interpretation of Article 143(1) of the Constitution 1992, Parliament had no power to provide that a regional tribunal had jurisdiction in all criminal matters. Please proceed.
Fantastic. So why should the draft, as far as 2000, this proviso, this exact drafting has been ruled as unconstitutional, also finds itself in a 2026 bill. And there's a clear drafting. And the major problem they are having with this drafting, or this particular tribunal system, I think that is a drafting problem. Because remember that, Samson, one of the problems I have with it is that when you have a substantive statute, which is a court, because the Constitution defines court to include a tribunal. So a tribunal is a court. And there's a substantive statute of a court. The best they could have done to avoid all these issues about whether it's a power system or not was simply to bring back certain provisos, paying attention to what the Supreme Court, and amend the Courts Act than passing a substantive legislation. Now you have passed the substantive
legislation. But the substantive legislation they have passed practically amends all the provisions in the Courts Act about tribunals. So what you are saying has been done.
No, but I'm saying that it ought to, instead of it calling a public tribunals bill, it could have been called the Courts Amendment Act, which would have included the substantive jurisdiction and provisions relating to it, so that we will have one composite act or a code which governs our courts in its entirety than passing a law. One of the major problems you're going to have in future when you're doing a research, your attention, if you're looking at the Courts Act in itself and you don't pay attention to the tribunal, you can easily miss that amendment in that.
But how is this substantive?
Come again, Samson.
How is this a substantive point of concern?
No, it's a concern because if it is bad draft, in my respectful opinion, it's bad drafting. If you could have allowed it to be in the Composite Courts Act, because remember, we did not introduce anything new. This has already been part of the Courts Act and ought to have been taken out of. Now, concerns have also been raised about the issue about voting, the panel system, where the old law, allowed the numbers, and in case you are convicted and does not include the chairman who has a background in law, you are entitled to a right of bail if you appeal against automatically. But with this new act, that proviso is not there. So if the two panel members, remember that they have to determine evidentiary decisions, issues relating to admissibility, issues relating to hearsay, they are determining both questions of law and questions of fact, in which even as lawyers, sometimes we struggle with. So imagine that somebody has raised an objection to an admissibility of a document, which the judge understands, but the two other panel members who are not lawyers, have a concern with, and they overrule the judge. I'm sorry to say that you go on with the trial. But in the old system, once the majority decision did not include the judge, the chairman, who happens to be somebody who has a background in law, that you are entitled, in case you are convicted, you are entitled to an automatic bail, because the drafters of the law felt that if the chairman was not included in the majority, there may be issues of law which may raise higher concern and injustice that may be caused to an accused person.
But if injustice is occasion, maybe my final question to you, people can appeal. There's an opportunity to appeal, unlike the 1979 one where you could not appeal. Now you can appeal. So why? Justice, the doors of justice have not been shut.
The greatest punishment that is given to a murderer is that of denying of your liberty. And for that matter, it's a criminal trial. And the major issues relating to criminal trial in this country, if you study the system, the delays are not caused by the courts. Let's be real. The delays oftentimes are caused by the prosecutors. If you study the trend, an instance where prosecution have to amend its charges on major profiles, an instance where the police decide to describe people as galamseyers, and understand that people's profession are galamseyers, and they admit it. So I think that these are and also the other issue that I wanted to raise with you, Samson, it's also about the inherent jurisdiction of the court, issues related to the stay of proceedings, that there shall not be stay of proceedings relating to the trial. And I think that for a statute to take away the inherent jurisdiction of court may be problematic, because if there's a clear bias on the part of a judge, for instance, or a clear bias on the part of a panel member, in which you want to raise issues of prohibition, and you have a ground to raise stay of proceedings, you cannot raise it. And I think that when it comes to criminal trial, the benefit of the doubt is always given to an accused.
Do we know if the power to stay proceedings, which this law bill takes away, has changed in the final product? Maybe it has changed.
But if you are a drafter and in drafting, as I've understood, you should draft in line, understand that there are human rights and also the personalization of it. And that's why I always prefer that when these laws are being passed, there will be a policy behind it and possibly even a budget behind it. How much is the tribunal going to cost us? For now, we do not know, because passing a law to set up a tribunal is one thing, but the operationalization of the tribunal may cost you no less than $10 million if you want to effectively do it well and not even discriminate against the 5 northern regions.
All right. Thank you very much, Dennis. When it comes to staying proceedings and doing cases in such a way that they are not truncated, I like to take the example from Kenya. Many times we go there to learn. When you are doing an election petition for parliament or so like this, the case starts. Once the whistle is blown, nothing stops the case until it is finished. But here, we'll file several interlocutory processes and we'll stop everything, and it will take us 7 years, and then we'll come and do nolli proscribe and free people. Yes, Dr. Bonfe.
Samson, I want to precede my submission with 3 quotes. The first I take from the Seventh-day Adventist Church daily Sabbath school lesson for the 16th of July, Thursday. He says, Christian leaders follow the footprints of Jesus by being willing to suffer for their fellow brothers and sisters, and if need be, die for the sake of their ministry. Then I go to column 281 and 282 of the Hansard of Parliament dated July 10, 1953, in seconding the motion of destiny. Then Kabachera J.A. Brima, who later on became Yagbon Retimu. He said, I hope you will agree with me that the price of success is self-discipline, effort, and constant vigilance. And with your permission, Mr. Speaker, I will quote the wise words of a United States Secretary of State. He was referring to Elihu Root, 1907. About 46 years ago, he said, self-control, self-restraint is the primary discipline on which self-government must depend. And that requires intelligence so that the true relation of things may be perceived, and also the moral qualities which make possible patience, kindly consideration for others, and the capacity for loyalty to certain ideals. Men must be willing to sacrifice something of their own individual interest for the larger interest of city, state, or country. And without that, popular government is impossible. The last quote apparently was made on July 20, which is 2 days away from today, by the founding president and the founder of our country, Osagyefo Dr. Kwame Nkrumah, when he was founding the Ghana National College. His advice to there were about 8 students or so. He said, think, study hard, work with sustained effort. As never before, we want thinkers, thinkers of great thoughts. We want doers, doers of great deeds. Of what use is your education if you cannot help your country in her hour of need? This week, Parliament had the 20th DF Annan Memorial Lecture. And it was given by the revered retired jurist,
Justice William Atuguba.
He said something to the MPs, pointing to them. that when he sees or watches or looks at Parliament, he sees something else. And that they are pursuing partisan, personal, self-aggrandizing, and not the interest of the state. I was shocked. Samson, you have copiously referred to the work of the Emeritus Professor Justice Fiajo. Commission Review Report. Voluminous. And the elaborate work they did. You refer to the white paper. But I want to read something very instructive as to how Article 142, the regional tribunals, came about. This is what they say at page 259 in the Commission Reviews Report. Samson, at paragraph 242, the Commission observes that in preparing the state for Ghana's return to constitutional rule, the committee of experts that developed proposals for the 1992 Constitution had to beat the tortuous path of reconciling the public tribunals as enabled by PNDC Law 42 with the constitutional principles that they were building. It was necessary to ensure that the public tribunals did not lay claim to any immunity from the constraints imposed by the Constitution. The committee of experts opted to integrate the public tribunals fully into the existing traditional court structure. So if you read Article 142, what they did was that they collapsed the tribunal system and left the regional tribunal, which was going to operate or was supposed to operate with the rules of court by the High Court. So, for anybody to be under an illusion that there is the tribunal system in the Constitution is something I cannot understand. It doesn't exist.
It is.
It doesn't. Now, let's go to the memorandum accompanying this bill. And I want to ask if the problems that led to the abolition of the tribunal system are not fixed, what are we proposing today? What are we proposing with this bill? And something, the memorandum was signed on May 15, 2026. That's instructive.
It was gazetted on 18th May.
Well,
2025.
I am referring to the
yes, I know. Yeah.
date on which Honorable Dr. Dominic Ayine, MP, Attorney General and Minister of Justice, signed this memorandum accompanying the bill is May 15, 2026. That date is instructive. Now let me come to the bill and the motivation for it. First, I look at it and I'm asking, is this supposed to be amending Article 142 and 143 of the Constitution 1992 and pretending about it that it is not? Two, it claims at paragraph 1, 2, 3, 4 that regional tribunals have become defunct in practice, with some stakeholders perceiving the regional tribunals as remnant of an authoritarian past. The memorandum admits this. And yet goes ahead to say that the Tribunals Bill seeks, therefore, to address the lacuna in the legal framework of Ghana regarding tribunals. There is no lacuna. There is no lacuna. This is dishonesty. And let's be fair and clear with ourselves. My seniors at the table. Samson, has the government not issued a white paper on the Age Question Prepare Committee by the introduction of this bill? It has.
Effectively.
Effectively. So let's stop being dishonest with ourselves. Pretending, and I'm happy with what Dr. Kwapon said Next time you are inviting people as experts to committees, given how we have treated the Emeritus Professor Akufo-Addo Commission report and the white paper which was issued with President Mahama serving then as Vice President, and had the period to make sure that the commission's report was implemented, and failed to do so for nearly 4.5 years. You set up a committee, and Eoco Prempeh tells you they are borrowing from, they didn't say so, but they borrowed from the language of the Emeritus Professor Akufo-Addo Commission report. You haven't issued any statement because the nomenclature and the authority in appointing that committee is questionable. They don't state so. I'm talking about the Eoco Prempeh committee. And that is why the government will say that it is not obliged to issue a white paper. It is not the same as a commission. Now, you haven't said anything about that committee's work. And you introduce a bill that is flying in the face of the committee's recommendations. Next time, if you are inviting Vicky Bright as an expert to come and serve in a committee, will she be willing, considering this?
And we should be interested in knowing how much it cost us.
Thank you.
To do the Eoco Prempeh committee's work. In the Professor Akufo-Addo committee work, it was valued at $6 million. They went to all 170 districts at the time. They held 57 different sessions, and they received over 83,000 submissions. And yet, a government decided to cherry pick and say, we want this, we don't want this. Who are you to say we want this, we don't want it? We say this is what we want.
Samson, I want to deal with the memorandum and its deceptions. The bill aims to clarify the jurisdiction, structure, and operational procedures of tribunals to ensure tribunals align with the principles of the Constitution, protect rights of citizens, and adhere to due process. The tribunals don't have any authority in this Constitution. There's a regional tribunal. It is not the same as a tribunal system. And that regional tribunal, as established in Article 142, is very clear that 142, it says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. The regional tribunal shall consist of A, the Chief Justice.
All courts consist of first, the Chief Justice.
One chairman, and such members who may or may not be lawyers as shall be designed by the Chief Justice, as shall be designated, by the Chief Justice to sit as panel members of the regional tribunal and for said period as shall be specified in writing by the Chief Justice. So this argument about time and elements is already catered for here. You see, we look, let's be fair. We are playing and toying with our democracy by the actions we take daily in our political front.
We're presuming that the tribunals will be bad.
It's not presumption. There's a history which has been catalogued. And we know that.
But it went through a transformation.
Which transformation? Which transformation? Tell me. Dr. Kopong has just told you that when he hears the word tribunal, Miss Vicky Bright has told you when she hears the name tribunal. My brother Bafo has talked about when he hears the tribunal. You have said it. In fact, even my brother who is...
We have family tribunals, so they are...
Hold on. I said when they hear the name tribunal, and those are family tribunals working within the rules of court.
We have the electronics, whatever tribunal.
Yes. But
the Go Board has
that notwithstanding, when we hear the name tribunal, it sends shivers within the spines of people. And people have done away with it. So when you promised it as a campaign message, Samson, I asked myself that when this commission report was presented, Professor Mills was the president. He had been sponsored by the NDC. When they issued the white paper, Professor Mills was president. He had been sponsored by the NDC. Vice President Mahama today was vice president. The Eoco Prempeh report, committee report, was under President Mahama. He had been sponsored by the NDC. In fact, the majority in parliament were sponsored by the NDC. So the question I posed was that, truly, these works that have been done by experts in laborious exercises under the jurisdiction or the leadership of this party-led, did they consider them before they made that pledge? And that's why I make reference to J.A. Brahma. That restraint is the key. The fact that you have power in terms that you have. And that is where I want to end. The majority leader saying that whether we like it or not, as Ghanaians, even though he was speaking to the minority, they were going to pass it. The question is, you are passing it for who?
All right.
There are problems with our judicial and justice system. They include lack of resources. They include lack of personnel. They include lack of logistics. They include the issue of, even when appointments are made today, under Article 70, Article 71, 72, we question when the president has nominated people to go to the Supreme Court. When Supreme Court decisions are made, we say that they are so-called unanimous FC. Even under this, now what will happen when we are introducing the likelihood of partisan people?
All right, thank you.
Without any legal
Thank
background.
you very much. And I'll read some messages to you. We take a break and return to Eoco, where a lot of questions are being asked. And Hanan has also filed a petition to the Attorney General complaining about a number of things. Abdul Hanan buffer stock, including that when he was arrested again at the airport, his money, about $6,700 or so, they took the money from him. They haven't given the money back to him. He doesn't know why, if that is also what. So we'll ask a couple of questions there. A couple of your messages. Nana Inspector says that, please, will the role of the lay magistrates in the UK not work in Ghana? We have had lay magistrates, except we are phasing out that system to make them professionals. You know, the lay magistrates are not qualified lawyers. You say, I have been in court for 3 years regarding a tenancy case, which has been already ruled by the rent control. 3 years. It shouldn't last that long. But there was a case, a small land matter for a family. It took 40 odd years. Judges died, parties died. It happened in Ghana. And Justice Georgina Wood described it as a parody of justice. Lawrence Boache says that the reintroduction of the tribunal system in the country, by the NDC Mahama government is one of the backward laws made in a civilized Ghana. While it is meant to intimidate the opposition, it will also evoke unpleasant, scary memories for some Ghanaians who went through this kind of judicial system under the leadership of Chairman Rawlings. It is absolutely needless. Well, some will say the NDC will not be in power forever, so why not wait when you also come? That's what you guys have been saying. When anybody is arrested, you say, tomorrow is pregnant. Sorry. Musa Abatua in Asawasi says that listening to Nana J. Bafo confirming that the NPP is opposed to the tribunal court raises serious questions. If the tribunals are intended to reduce the burden on the courts and speed up justice, then there should be no reason to oppose them. Those with nothing to hide should not fear such reforms. I fully support the establishment of the tribunals and believe they will help strengthen Ghana's justice system. Hashtag Newsfile. Ishmael in Adar says, I think the whole noise about the tribunal is the history and baggage that it carries. It stirs emotions and sends fear down the spine of Ghanaians, especially those who are old enough to know what the tribunals were used for. We'll take a quick break. We'll be right back at Eoco, not demonstrating, but checking the facts.
Mommy, good morning.
Oh, good morning, my son. How are you?
I'm fine, thank you, Mom. How about you?
I'm fine.
Joe, I just saw your mom doing her usual morning routine. Like,
It was just 2 weeks she underwent a major colon surgery.
Bro, see, my mom is doing perfectly fine, and we're all excited about it. It was minimally invasive surgery, and the recovery has been very fast.
Minimally? Hey! No, wait. What do you mean by that?
So they offered my mom a laparoscopic colon surgery. Laparoscopic colon surgery, which we accepted. It turned out it was equally safe with a very fast recovery time, and the cost involved too was very, very reasonable. She was discharged 3 days after the surgery, and you can see her, she's on her feet again.
3 days?
Just 3 days, bro.
Mean Tuber Hospital, first Ghana colorectal center, aimed to serve a peculiar health need.
So this strategy will lead.
Oh no, not again.
Sir, relax. The generator will come on now.
The generator is not working. Why stress yourself when the experts are just one tap away? Introducing Left Power, the smart emergency support app from Left Signature Limited. With Left Power, certified engineers respond fast, anytime, anywhere. No delays, no stories.
Hello, sir. This is Left Signature Limited. The request has been received and our engineers are already on their way. Please relax. We've got you covered.
This is professional. Every Left expert is certified, verified, and can be tracked in real time. Oh, you'll know they're coming before they even arrive. From electrical engineering and solar power systems to data center management, cloud services, smart automation, and software development, Left Signature delivers excellence, fast, reliable, and professional. Left Power.
Your solution is just one tap away.
Available on Play Store and App Store.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach. You don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights and discover spaces crafted for comfort, style, and everyday living. And just when it feels right, you will know. Because this isn't just about finding a house. It's about stepping into a better way of living. Eden Heights, the height of modern living. Book a private viewing today.
Na se afi 1924 enye afi bia keke na mumu abrabo ahyase. Na se abrabo enye bibi kesi bia na mumu niema ketewa a efete se edwuma edikan akukuduro a yedisi ginaye na woni obi etu anamon abomu na se bombo emma wo ahoto te se chini a ekura yen wa abra nsu kesi bi ato mpofi mu na se bibie mu no wedwuma sam ekoswe na se apomuden edi enidaso ba na akomabubu nso ewo hye fofre na se ahunjie eye emre abasobode afa hudie eni enijie ewo mue na se wabrabo mu nsem egina wo fie eni wedwuma sem ho nso na se ye di odo bata nia ya hwere ho a ye nkredie ebeye fe.
Enterprise, your advantage.
welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And thank you very much. There are tons of messages from all of you, but it's only a few of them that we could read. Anderson Jr., let me read this. He sends us this from the UK. He says that I'm a bit handicapped in these matters, but is the argument really about the usefulness of tribunals or historical excesses some associate with them? Our legal system is largely built on the British model, and the UK continues to use tribunals as an important part of delivering justice. If there were problems with poor administration, weak case management, or delays in delivering justice, let's interrogate and fix those. But simply rejecting the idea based on historical sentiment doesn't address the real issues. The focus should be on making the system fair, transparent, efficient, and independent, not rejecting them altogether. All right, that's your view. Okay. Then, Papa Bisu, you say that the tribunal is into strengthening our judicial system in promoting justice delivery on a more faster note. No wonder the MPP guys, fearing most of their corrupt ones, will soon have a change in their sleeping zone, hence against the tribunals. Okay. Sometimes the way we make our comments, I think it's that easy. Just for political point scoring. Yakubu Ibn Chambers says, if what was cast into the abyss is gone back for then I shudder to understand and have any doubts about the direction this country is heading. Going back for the vomit of the tribunal system makes mockery of the sleepless nights put in by the Professor H. Kwesi Prempeh and Emeritus Professor Fiajo Constitutional Review Commissions. You don't talk about the Clara Berry Committee as well. Okay, those related to the NDC regime. Okay, our politicians are toying with our democracy. Ibn Chambers Yakubu sends us that from Wale. Thank you for your message. Okay. All right. This one says, I heard you mention a case in Georgina Wood said that it's a parody of justice because it took 40 years to give judgment. Okay, I'll fetch it for you. Thank you very much. I have it. Just seeking to have a copy of it. Thank you all very much. Now, let's go to Eoco. Dennis Miracles Aboagye was arrested on his way back to Ghana at the airport and spent about 4 days in custody or so, and then got granted bail in the sum of 50 million, and that has brought up another hue and cry. Eoco coming up for questioning a number of times on some of these issues. And as I mentioned to you earlier, there's a petition that's been filed by Hanan, the former buffer stock boss, to the Attorney General, and is complaining about several breaches and violations of his rights by Eoco. And these have been said over and again. Is it just people who have been caught by the law crying foul, or these are genuine concerns that they are raising? He speaks about the fact that he was initially arrested in June 25, 2025, and kept in Eoco custody for more than 2 weeks under unjustified and onerous bail conditions of 60 million, calculated to prolong his detention without being produced before a court. Of course, subsequently, he was produced before a court, and he had to spend another 2 weeks in custody. The court had actually enhanced that bail term from 60 million to 100 million Ghana cedis, and that's got him into a bit of some trouble, having to spend 2 more weeks in custody. Then, his charges were withdrawn. He was discharged, and then subsequently, he got rearrested, and he had to suffer one more round. Again, once he was discharged, The court suggested to him that he has access to his money. He has been accused of attempting to take the money without due process. They haven't shown him what check, what day, what time he went to the court to withdraw any money. And a court gave an order that he should travel, and he was stopped. He couldn't travel for his medical treatment. But I'll mention this last one. He tells the Attorney General that they have abused his right because when they arrested him again, he had certain things on him, including money. And he says this money, $6,700 US cash. The officials took it from him. They have not given the money back to him. He doesn't understand why, and he wants the Attorney General to crack the whip and hold them responsible for it. Several other things, he says, have been taken away from him. He's copied the petition to the Chief Justice. Yes. On this note, yes, Nana, we begin with you again.
Okay, so...
Why? If your people have suspicions of wrong, they shouldn't be arrested and dealt with?
Let me put it on record that we have not complained of the arrest. Our complaint has been the way and manner our people are treated following the arrest. The MPP is not against accountability in any shape or form. However, the manner in which our people are handled then gives suggestions that it is not merely for accountability but other things. And that is why when these things happen, obviously, we'll come to the aid of our people. Look, you are a government. You have the law in your palm in terms of how you use it. Nobody will stop you. If you have anything or believe that somebody has committed one wrong or the other, take him through due process of law. There is a trend that cannot be ignored. What Chairman Wontumi went through, what Hanan went through, what Provençal went through, what Dennis Miracle Aboagye is going through, and many others who have gone through it. It's a trend. If you suspect that somebody has committed an offense, you have invited the person for investigations. Let's take Miracle's case. Let's even take it from the perspective or within the context of the statement that was issued by Eoco. From Eoco's statement, they had been investigating him for a year. That then suggests that there had been previous invitations where he had attended at the instance of Eoco for a year. And so if you have somebody who you've been investigating for a year and has been cooperating with you for a year without drama, why arrest him upon his return to Ghana, not when he is leaving Ghana? If you need him, is it a case that you invited him and he failed to respond to your invitation? From your statement, there was nothing like that you had previously invited him in the course of your investigations, but he had failed to honor the invitation. From your own statement, he's been cooperating with you for a year. Nothing suggests uncooperation. So why the need to do what you did at the airport by arresting him?
They said, following significant new findings last week relating to suspected fraud and theft involving Mr. Dennis Aboagye, who is already aware of the investigation and has already visited the office on it, Eoco initiated an operational plan to effect his arrest this week. That was last week. As part of this process, Mr. Aboagye was placed on the stop order a week ago to prevent any sudden travel that could impede the investigation this week. Unknown to the office, he had already departed the country. So upon his arrival, immigration took hold of him and handed him to them.
Let's analyze the account you just gave. So Dennis is aware of an investigation. He has been visiting the office. If there is a significant findings, right, the same way you invited him to the office that he responded, this statement doesn't state that he was invited and he did not respond. Why place him on a stop? Why place him on a stop order? Is it a case that you were suspecting that he will run away for the period? If you were suspecting that he will run away, why didn't you invite him prior to his departure? Clearly, the statement doesn't add up. My brother, this is the reason why we don't believe that there is indeed a genuine investigation.
Investigators use all sorts of, tactic, and they have to be calculated about it. If for some reason they feel that this time we have to ambush him, pick him up.
Ambush him where?
Because they had to take him to his home, and they said he cooperated. They took him there over the period that he was with them.
He's done all that.
Maybe inviting him quietly would not serve that purpose.
Okay, so now, Samson, you are doing the devil's advocate. You are playing the devil's advocate very well. But Samson, so they were in the mind of Dennis to know that at some point he will be traveling, right? But they were not in his mind to know that, he can do some other things to interfere with the investigations. Is that what they are suggesting? I mean, if you knew that he could travel side that you put him on a stop order, then you should be able to tell where he is at a material time to be able to hold him and then do whatever you want to do. I mean, clearly, what they did, Samson, is unjustified. And when you add it up to things or some other things they have done in the past in relation to some members of our party and some appointees of the former government, clearly it tells you of acts of intimidation, very unnecessary. You see, post-2000, the National Reconciliation Exercise was aimed at putting certain things behind us so that we'll start on a clean slate. And that we're hoping that on the back of that, we're going to let the Constitution become paramount and work according to due process of law. When you proceed along these lines, it becomes very difficult upon a change of government for an MPP government not to do same. Because you see, when you are in government, Samson, you also have to listen to your grassroots. And if you don't have the heart of the likes of President Akufo, who say no, of the heart of Professor Mills, who say no, but would want to go for an eye, we are going to end up destroying this country.
They are effecting Operation Recover or Loot. And you guys have been on the rooftop saying it is dead, it is dead. They must show you that it is not dead, it's alive.
Recover it in court, not by such abuses.
What's the abuse? 50 million bail. What's the abuse about it? That's the question they are asking you.
Samson.
You have to demonstrate once again at Eoco's premises. For what?
Samson, genuinely, you're a lawyer. Tell me.
Don't ask me a question, please. Ask your other members. I do the questions here.
Samson, let me take you to Article 14.4.
Yeah.
Where a person arrested, restricted or detained under paragraph A or B of clause 3 of this article is not tried within a reasonable time, then without prejudice to any further proceedings that may be brought against him, he shall be released, either unconditionally or upon reasonable conditions, including in particular conditions reasonably necessary to ensure that he appears at a later date for trial or for proceedings preliminary to trial. Are you telling me that when you are yet to conclude investigations, first and foremost to know the quantum in issue, secondly to know that there's a prima facie case against the person, for which reason within 48 hours or immediately thereafter you are sending the person to court, you are telling me that the imposition of 50 million cedis bail is reasonable? It is clearly not reasonable.
You said they don't know the quantum. They say 55 million.
You have not concluded with investigations. If you had concluded with investigations, you would not be releasing him on police inquiry bail. You will be taking him to court. The reason why...
After 1 year of investigation.
Yes, after 1 year of investigations. If you had really concluded with your investigations, you wouldn't be giving him bail. You would take him straight to court and let the court give him a court bail. But you have not been able to do it because clearly you are not done with your investigations. And so you are yet to even establish the core elements, right? I.e. the quantum of claim, i.e. whether or not he himself is culpable. And that when you have not been able to do it, why do you have to impose on him such hefty bail? When we all know that if you want Dennis Miracle Aboagye, right, he's in Ghana. He has not gone anywhere. He's a very important part of the New Patriotic Party.
Somebody would have said the same thing about Sedina, Tienu, Tamaklo. Somebody would have said the same thing about Ken Ofori-Atta. These are men of integrity, wearing white and reading their statement and quoting the Bible. They won't run anywhere.
Sedina Tamaklo was not a key member of the NDC in terms of structure until her appointment. Who knew Sedina? Nobody knew Sedina. Ken Ofori-Atta, he was not charged by anybody before he left this country. Ken had not been charged. And so they are distinct matters. Miracles Aboagye, he had traveled and he was returning home. If he didn't mean to return, he wouldn't have come back. And from their own statement, for the last 1 year, he knew that he was being investigated. So upon all this, he decided to return home. It tells you that he's not a flight risk. And so imposing on him 50 million cedis bail is clearly unreasonable. And I hope we don't continue doing this to ourselves. And this is why, Samson, I think that we should really...
You read the Constitutional Provision Article 14. Which part of it has Eoco breached?
I think that the imposition of the 50 million cedis bail.
I read to you Hanan's situation.
That is
Eoco had given him 60 million. And we were all doing yay with demonstration. He went to the court upped it to 100 million.
And we have been complaining about how the court has been handling these matters too.
So Eoco is taking a cue from the court.
We have been complaining about all these matters. We don't think it is fair. Because, look, it flies in the face of the constitutional provision on the presumption of innocence. It completely flies in the face. And in some instances, it's proven that once such bail conditions are imposed, it becomes difficult for people to meet them, and so they stay in prison custody longer.
Look, Eoco is setting about the case it has. It says Dennis Miracles Aboagye, who was the executive secretary of the Interministerial Coordinating Committee on Decentralization, there's an audit, and the current person in charge of that brought a petition over the audit, and it concerns suspected misappropriation, misapplication, diversion, and thefts. They are categorical thefts of public funds amounting to 55 million. So they say that the former executive secretary, Dennis Aboagye, and the former accountant, Mr. Gerald Appiah, and others are under investigations for suspected offenses, including conspiracy to steal and stealing, using public office for profit, causing financial loss to the state, dissipation of public funds, defrauding by false pretenses, money laundering, and other suspected offenses. They actually say that the accountant has started paying back their money. So it looks like you have a watertight case.
Dennis has come out to deny this. Dennis has also stated, and in fact, his point is also corroborated by his lawyer, Atachia, that during interrogation, no mention was made of any 55 million. And so clearly, what we are being told might seem to be not what it really is. And so we have to be very cautious in accepting what Eoco is telling us.
All right.
But ultimately, if you look at the chronology of events, right, you come to the conclusion that the arrest at the airport was not necessary because he had been cooperating with you. It is when somebody has not been cooperating with you that you do things to secure the person's cooperation, right? Secondly, when you listen to the chronology of events, you also come to the conclusion that the imposition of 50 million cedis as a bill condition was also very unreasonable and unconstitutional. When you listen to Dennis Miracle Aboagye, you also come to the conclusion that the reference to Mr. Apia, is that not the name? Mr. Aboagye?
Gerald.
Gerald.
Okay.
Right, the reference to him, right, and connecting it to his case is completely, might seem completely not
unwarranted.
Unwarranted. So,
okay. So we hear certain comments that suggest that like you said, that the reference is unfair to him because there is some information that suggests a completely different scenario, and that this is an audit finding, and in audit finding there are surcharges. So it looks like in the case of Gerald, he's only trying to pay money for which he has been surcharged. So to suggest that he is paying money which he is being charged for by Eoco is not correct. Okay. Yes, Theophilus. And I was going to ask Ajay this, but sometimes we need to make progress, right? Because people refer to a colossus like Chachuchi Kata.
I'm going to say.
And where he was arrested. Yeah. You didn't need to do all that Gestapo thing. But people are saying, let's move on. Let's not go back to the excesses. He was arrested in church.
Yeah, Samson, before I come to your question, let's be fair to the government in the Professor H.K. Prempeh Committee's work. The work is not only about the tribunals. So to suggest it appears like this act or bill has sort of thrown their work somewhere is not fair to the government.
Oh, nobody will come to that thinking.
But so that next time we are doing other work,
right,
people will not come in and cooperate, etc. No, let's be a bit fair. Yeah, I was going to talk to my brother here to say that I believe that no Ghanaian has the right to decide when and where he should be arrested. You can be arrested based on the principles we know we have all been taught as lawyers how arrests are effected. Now, I was going to say the Chachu one. The Chachu was arrested, Victor Solomon was arrested at the airport. And that happened under Akufo. When you said Akufo says that, no, we shouldn't do what was done. It happened under Akufo. The Chachu Chikata was arrested in church. I think the airport one too also happened under Akufo. Indeed, just recently, the MP for Medina, Sosu was nearly arrested the same way. So for us to say that, okay, you are listening to the grassroots, I was expecting you would say that, oh, having tasted what was done previously, we are all coming to the point that it will never happen again. Now, let's focus on the statement. They said that they have, as he read, new information, and they felt this week we are going to arrest him. So in order to prevent his departure, a stop notice was placed. Now, this is what happens. When the stop notice is placed, when you are coming in or going out, immigration will pick you. The stop notice will not be if he's coming in, then allow him to come in. The purpose of the stop notice is to prevent the person from disappearing so that the person will be located and brought to Eoco. So the idea that he was picked from the airport when he was coming in does not in any way violate how he was arrested. We have seen it before. Now, you also mentioned the idea about the 50 million being unreasonable, unconstitutional. Something we have discussed this year, at least twice. And Senior, you were in the same platform with me. Now, we have all been taught in law school. If you feel that that provision, that amount that has been given or has been mentioned at Eoco or police station, etc., you feel it's excessive because the law makes it that bail should not be used as a punishment or the conditions should not be used as punishment. Now, if you feel that that is unreasonable, unconstitutional, you proceed to court immediately and ask for the variation. Indeed, we have been given an example that when they proceeded to court and the court varied it and even increased it. You see, there is an issue which I believe Samson will agree with me. As lawyers, when you are negotiating or talking about bail or making application for bail for your clients, your demeanor and candor and everything also goes in. Because bail is at the discretion of the judge. And if you read Martin Kpebu, one of the things Justice Doche Emeritus said is that for the fact that all offenses are bailable doesn't mean that every Tom, Dick, and Harry just appears, then you grant bail. No, they still have to be at the discretion of the judge. So in this instance,
but that discretion must be judicially exercised.
Yes,
under the scope of the
23
Criminal Act 30.
Yes,
correct.
That is
the person a flight risk? Is the person going to compromise investigations? Good. You look at those things. Has the person has a place? Does he have a place of abode? Good. Is he a responsible person in society? Those kind of things.
Good. And that is what you gave an example that people will mention. Sedina. Indeed, you mentioned here that we should distinguish Ken Ofori-Atta's own from Miracle's own. Indeed, Ken Ofori-Atta was not charged. Indeed, Miracles has not been charged. So where's the distinction? It's the same thing that there's the apprehension and fear that somebody could be flight risk. And we don't know, Eoco has not gone into detail to tell us what they have become aware of that week. That has made it that they have stepped up their operational plan to effect his arrest. We are not aware. But they are making us aware that there had been change in situation that made it that they need to arrest. Now, I believe, and I believe something you are aware, that somewhere about 2-3 years ago, Xavier Sosu, the MP, was bringing up a proposal to Parliament for us to come to the terms of how bail is granted at the police station or even at the court. That there should be procedures if this box is ticked, this is the amount or this is the condition. But where did it end? You were in government then. I believe that this is the time for you and others of similar thinking to join hands to say, we have had all this for a while. Now is the time. What is the policy? How do we amend the act such that if the person goes to the police station or the person is arrested by the police, arrested by Eoco, arrested by BNI, these are the conditions. If the person meets this condition, the person should be granted this amount of bail. If these are the conditions, then we know that we are making progress. But each day to say that for the fact that the person is arrested, let us go and demonstrate. I will not end without mentioning the demonstration. We were here when the MPs went to Eoco to demonstrate, as we saw last Monday. At the end of the day, the person for whom they were demonstrating is negotiating for a plea deal. Then was it that you jumped the gun too much of the, what's it called, the negotiation or the demonstration? Every lawyer will tell you.
Some of the demonstrators didn't know who they were demonstrating for and why they were there. Waiting for 50 CDs after the demonstration.
Yes, and if you see, I saw a video where someone brought food and drink, and there was an alcoholic drink thrown on top, also to be distributed. So some of these things, but every lawyer knows that it feels so bad when your client is detained. If your client is not granted bail, no matter how hard-skinned you are, you will feel it.
Can I ask you a small question?
You can always ask me, even the bigger one.
Self-recognizance bail.
Yeah.
What is it?
It is, okay, I will answer it and add to it something I discussed with you before.
Okay.
That we should gradually move from what the justification is. And I remember telling you that there was a particular judge who once said, if I say justification, except I say justification with landed property, just swear affidavit of justification, attach your Ghana card or voter's ID card, then you submit.
That's interesting.
Yes. And she's done it in cases I've been in court. And I have samples of the ones we submitted. Justice Mary.
Okay.
She's now a court of appeal. Yenzu.
Okay.
Yes, she did it. And to the extent that the law firm of Martin Kpebu even cited the police then for contempt for not obeying what...
So justification does not necessarily mean you must show a landed property.
No. She said there was a training where that, so it is important that as lawyers, when the judge says justification, go further. Ask the judge, I mean, we are aware that you can have justification this way. Should it be by landed property? Should it be by even maybe non-landed property?
Yeah.
So you must be able to go further and have that discussion with the judge to be able to ascertain this thing.
Maybe some financial instruments.
Exactly.
That one we also know can be used.
Exactly. Yeah. Then the person goes on and moves on. But we have all sort of dovetail into the situation that...
And when you are bringing the landed property justification, they'll have to go and check with Lands Commission and
whether you have registered.
And if the verification is taking 2 weeks,
yes.
2 weeks you are in the
you are in custody. And in certain instances, it depends on whether the registrar is willing to stand up and go and do it with you or not, whether the investigating officials are willing. It's 3 o'clock, we are going home. Some of all this, that is why I'm appealing to you as the member of parliament that this is the time. Let us get the rules of engagement around bill properly codified so that we understand that when this happens, this is what...
Now back to my question.
Yes, our answer, self-wrecking bill means you sign for yourself that I'll present myself. I don't need anybody to say that they will bring me.
Why do you think that in all these arrests, the people who are involved, none deserve self-recognizance?
I think I think they deserve. I think when we had a case of I think Akufo-Addo, I think they were on a self-recognizance bill. Again, Samson, we are
because self-recognizance means you must have a sufficient reputation.
Yes.
That we can trust that you won't run away, you are around. And all the people who are getting arrested, none has a reputation.
But again, let us not forget
for themselves.
Let's not forget that one, we do not know the background or the information they have so far about the investigation.
That's right.
Whether you are a person of straw, person of magnanimity, etc., we don't know.
Right.
Again, they also have history to the extent that persons of character that we know, as you said, wearing white, etc., just disappeared even before they were arrested and charged. So some of these things, we can't remove it that it plays at the back of the mind of the investigators. Thirdly, the bail thing, again, is discretionary. And self-recognizance is one of them. And one with sureties is another. And the person decides that in the scheme of things, I am going to take the one for surety.
They said 55 million. And Dennis, upon his release, has disputed that. And they refer to Gerald, the finance director, former finance director of the committee, Gerald Appiah, that he is paying back. The explanation we have understood is that the former finance director was surcharged an amount of 500,000 after the audit, which he has almost finished paying. So for Eoco to create the impression that he was refunding a so-called 55 million, which he stole with Miracles Aboagye, is unfair.
Yeah. So for me, Samson, first, I do not have the, let me use the word, luxury of what you're reading. I'm relying on what Eoco has given us about the statement Eoco released. I was also surprised when my colleague here says that
we understand it is his lawyer who is disputing that he's refunding any money.
Samson, as lawyers, we do not, and again, that's why I'm driving to that. He said Miracle said something and it was corroborated by Atachia, and clearly Eoco might not be telling the truth. Nobody of plain and non-biased mind who expects lawyer Atachia to say something different from what Miracle said. It will never happen. They will all have to sing from the same hymn book. And until we wait for Eoco to come back to tell us that, well, we have read the statement by the lawyers for Mr. Gerald Appiah, we have seen the statement by Miracles. Indeed, Miracles said that the 55 million was not mentioned. He didn't go into details to tell us what was mentioned anyway. So once you have removed the one that was not mentioned, you leave the ordinary reasonable mind to say that you are not also being honest. There was something mentioned. Okay. Because you couldn't have been interrogated for 2 hours, an hour, 10 minutes, just on basis.
Alex Segwefia has given a caution to the members of the government. Have you heard him?
No.
You should be careful.
Yes, but
the thing you are doing to somebody today could be done to you tomorrow. So,
and on this note, I want to say that the director of legal and the CEO for MPA, Right. It has been his clarion call always to government appointees on all the platforms.
And Abraham Amaleba.
Yes, and all the platforms I share with him. And Eduji always mentions it to the CEOs, the MDs, the deputy CEOs that work according to the rules. And because what might happen tomorrow, you will not like it. So everybody should try and navigate the narrow path.
Okay.
And if this is being done every day, and to the extent that some are even calling for sort of re-energization or a sort of meeting again for the CEOs, for them to be reminded about these type of things. If all this is happening and you as an MD or CEO or executive secretary decide that, okay, I'm going to behave differently, at the end of the day, you will be held accountable.
Okay. Let's hear Atacha, who went to represent Dennis Miracles Aboagye at Eoco, and his concerns the night that the bail was granted.
You can see clearly that the bail terms are cruel and is a way to punish him some more. It's not possible for us to post these securities at this critical hour. And I could say that the rule of law of how is it going to be released? How is it going to post the bail bonds? How is it going to do it? 50 million Ghana cedis, 3 sureties, 2 to be justified. That means 2 of them should post properties. Well, 50 million. And even by this critical hour, where are you going to find properties worth 50 million?
I'm finding it tonight.
I'm finding it tonight. Mr. Kwan said,
we also, I also just want to touch on accountability and to say that we do not harbor any malice against any person. And indeed, I do not take any enjoyment or pride in prosecuting people if they have done no wrong. And I believe that our prosecutorial system, investigative system, and judicial system grants enough leverage for people to have justice. And so nobody would, out of political vendetta or malice, prosecute anybody if you've done no wrong. And if you've done no wrong and you are being prosecuted maliciously, the courts will be able to uphold your rights and set you free. And so it shouldn't be like we're trying to hound our political opponents or something. We proceed on the basis of evidence we have received. And then the evidence is weighed. And if it is sufficient, there are many times we have reports and all that. Sometimes the evidence comes and it's not substantive. And so you say, if it's on the weight of this evidence, you cannot proceed to court, so discard it. Or investigate further and see if there's something else that you have not found. But otherwise, if a case proceeds, and that is why the whole system of accountability is taking time, because you need to be thorough. By the time Eoco or OSP or somebody comes and arrests the person, it means that months of work have taken place reviewing the evidence. And so I just want to assure that accountability is still our #1 priority. But like I keep saying, the sword does not cut only one way. If we find evidence that any of our current appointees or persons working in government under our tenure also has abused the public trust, the way the sword is cutting that way, it will cut this way too. And so I always caution my appointees to be very careful. Be sure you follow the procedure, don't cut corners. And the point is, if you have any doubts, I tell the ministers every day, if you have any doubt, bring it to cabinet.
Right, Vicky.
Yeah, the sword does cut both ways. I agree with that statement by the president, and accountability is important. We all know, these are serious allegations, and Eoco is the properly mandated, institution to investigate and prosecute these actions. But there are some constitutional provisions which must absolutely be adhered to. We've talked about Article 14, and Article 19 is also important. Everybody in this country is presumed to be innocent until they are proven guilty by a court of competent jurisdiction and convicted as such. So in all these things, we have to tread with caution. the rule of law must prevail, absolutely, at all times. Because today it's one person, tomorrow it could be any of us in this room. So when analyzing these kinds of situations, we have to really be dispassionate about it in the sense that you shouldn't look at the individual concerned and how you feel about that person, because the matter is far bigger than all of us and far bigger than that person. You know, the Constitution requires a person who's arrested on suspicion of committing an offense to be released or brought before a court within 48 hours. From what we know, I think Miracle was in there for 50 hours, right? Mm-hmm. So that is not acceptable, because once your freedom is being restricted, even in 2 minutes, it's not a good feeling.
By their calculation, if before the expiration of the 48 hours, they grant you bail, but you are the one who is not able to satisfy the bail, and you spend 2 weeks like Hanan did, spend another 2 weeks like Hanan did again, that's your own problem. They have already granted you bail.
But Samson, here's the thing. I mean, 1 hour before the expiration of the time to look for 50 million? I mean, who in this country can provide that? Even if you're a drug dealer of the biggest magnitude, you still have to...
Property worth 50 million.
Arrangements, yes. But there are arrangements that have to be made, and you have to satisfy Eoco or whichever institution is concerned that, look, this is the property, I own it, it's worth 50 million, and they also agree to it before you are signed off. You can't just name the property and say, I own number one, whatever, in Trazaco Valley, and so can I go home now? It doesn't work like that. So these are some of the issues. So we need to be careful so that we don't put ourselves in a situation where it can be felt, or Eoco doesn't put itself in a situation where it can be felt that it's trying to avoid this constitutional obligation by structuring bail conditions in a way that could predictably keep the accused person in custody longer than they should be. That is the challenge. I mean, what is the purpose of bail anyway? To have non-lawyer viewers out there. What is the purpose of bail? Bail is intended primarily to secure a suspect's attendance during investigations and trial, period. That is it. That's all bail is supposed to do. So that is the test that has to be applied in every single bail condition. It is not supposed to punish a suspect before conviction. It is not supposed to demonstrate the seriousness of the allegation. In fact, the law says bail shall not be used as punishment. Exactly. Explicitly. It's there in black and white. It is not supposed to satisfy public demands for retribution, even though we all want our money if someone has stolen it. And it is not supposed to function as a substitute for a freezing or confiscation order. It's important to note that the person in question, in this case, Miracles, has not been convicted. He hasn't even been charged. That is my understanding. Yes. So the presumption of innocence must remain intact until he is convicted by a court, well, charged first of all, and if the case is proven by the prosecution, because it's the prosecution's duty to prove their case, then he can be convicted by a court of we are very far away from that situation at the moment. And the 50 million is interesting because for me, it's very close to the 55 million that's been allegedly stolen. So I'm asking myself that was part of the consideration that it should be calibrated according to the alleged financial loss, rather than according to the genuine risk of flight or non-attendance. From what we understand, he's been going in and out of Eoco for a year. He traveled and came back and was arrested. Yes, of course. Prosecution authorities have very wide-ranging powers, and you can be arrested in your bedroom. You can be arrested, as we heard, in a case from anywhere in this country.
The energy minister, John Jinapo, they were all, picked out of their homes like common criminals.
So that is not, yes. So the powers are there, but we need to do things differently. We are evolving as a nation all the time. I'd like to think that we've matured beyond a certain level. Let me put it that way. If the person in question is not known to be dodging Eoco or anything of the sort, in fact, in spite of being under investigation, they traveled and came back. So, I mean, yes, okay, arrest him at the airport if you must, but is it really necessary? You know, is it really necessary? Invite the person. If they don't show up, then that's a different matter. And this applies to everybody. I mean, it applies to everyone. So for me, the questions that should have been asked are, does he have a fixed place of residence? Is he likely to flee Ghana if he's not arrested at the airport? Has he previously refused invitations from Eoco? Is he likely to interfere with witnesses if he's let loose out there? And is there any evidence that he may conceal or dissipate assets? That is important in this context. And could the reporting requirements, you know, passport surrender, travel restrictions, adequately manage those risks if there are risks? These are the questions that should be asked. So I think we just need to be careful. Yes, Eoco, by all means, investigate robustly, because if public funds have been stolen, we all want that money. It has to come back to the state's coffers, you know, because no one person can just decide to dip their hands in the public purse and expect to get away with it and expect Ghanaians to celebrate. But I don't think anyone is questioning that. So far, all the commentaries that I've heard from all sides are, yes, if it is the case that this crime or these crimes have been committed, then Eoco must pursue them relentlessly. But we just have to do it in a way where it's not perceived, their actions are not perceived as converting Bill into some kind of pre-trial punishment. So that is what I will say about this for now.
The concerns that are also coming up is that when, during the period he was in Eoco custody, he was sticking to his residence, and they took photographs of the place, and it's on social media. And actually, some of the people on social media who are known to do work for Eoco are suggesting that when he was in custody, there were cameras on him, and there's a footage that they are likely to even show on social media if they have permission.
I mean, you know...
what's the name? Hanan is making similar complaints to the Attorney General that there are defamation, that stuff that he suffers even whilst he's going through the process and is cooperating, and that is unfair.
That is not right, because this is not about humiliation. This is about pursuing justice or pursuing, you know, an institution doing its job. And part of that job is not to humiliate people, because they are innocent until they are proven guilty. So if you already treat someone as being guilty and then go further to humiliate the person, I mean, that is way outside. You are now encroaching in abuse of human rights and perhaps even breaching data protection laws in this country, etc., etc. You know, so we need to be careful. Because as people like Edwardji and Alex Sebefia and others are saying, today...
The president just reaffirmed what they are saying. And the president
just reaffirmed that, and I started my submission by repeating, quoting from what he said. So let's just act professionally. Let's be dispassionate about these things. Don't look at the individual concerned. Just look at the facts. What you are seeing as the facts, the evidence that you are gathering. Do your job, pursue it robustly, but within all that, respect people's human rights, respect the Constitution of the Republic of Ghana, respect the rule of law, because we are not a banana republic.
Right. Kekujo has done a setting, I'm coming to Dr. Bonfe. Kekujo, the prolific writer, and who incisively, you know, looks at matters concerning the state, has done a certain research, and his research shows that
before they got in.
Inquiry bail, the bail that is given not by the courts, is increasingly more severe. Since 2025, Eoco inquiry conditions have frequently exceeded the court bail imposed in earlier major prosecutions, corruption prosecutions. And it has a tall list from 2014 to 2026. Aboagye Jida, he got self-recognizance bail. Philip Asibit was with Aboagye, he got 2 million bail. That's also 2014. 2018, Dr. Stephen Opuni got 300,000, is it, bail. And then self-recognizance, he got self-recognizance later, and then his charges got withdrawn later. Seydou Agongo, Agricult, he got 300,000. And then you had William Atuesian, got 200 million. Fitzgerald Odonko, 200 million. Those in the Capital Bank matter in 2019 all got 200 million. Sedin Atamekulu got 5 million. You know, Collins Dauda, okay, I'm sure he got self-recognizance or something like that. Ejenim Boating Ejay got 5 million bail. Nana Pia Mensah Nam1, he got 5 million bail, and the list is a long one. Millions, 30 million. Who got 30 million? Yes, the Fauza Seydou Wuni, that's the business executive, buffer stock corruption case, got 30 million. And then OSESB Entry, National Service Secretariat, got 800 million. Of course, the court later slashed it down to, is it 623, and then later to 120 million. When all those periods, he was unable to meet the bail conditions. Yes.
Sorry, yes. I just wanted to say one more thing. All these figures that you are mentioning, if the person has stolen the money, then they can provide it. But if the person is innocent, where are they going to get this money from?
No, actually, if you have the money, you can't use money for bail.
Yeah, no, I know. But I'm saying if you have, whether it's an asset or whatever it is, where are you going to get it from? If you are just a person doing your job and all of that, if you have stolen the money, then the chances are you've probably acquired assets to that tune. So you can do that. But if you haven't,
and it's actually someone who is standing surety for you.
Yeah, but you can do it.
So it's not your property.
Yes, you can do a deal.
No, they will have to check the documents.
No, I know that. I know that.
Yeah.
But I'm saying, I know that.
I mean, I understand what my sister is saying.
Stolen the money.
She has a very solid point in that. In 1964, the United States of America had just passed the the Civil Rights Bill. And it had been sent to President Lyndon Johnson, who had succeeded Kennedy.
For you. The other thing is that they said the reason they are not.
Hubert Humphrey, who became his vice president,
none of them want to bring their property.
Had authored a book, and it was published in 1965. He says this at page 25 of the law. After praising it, probably the most significant bill to have come to the Congress of the United States. He went on to say this. But the law can be no better than the people who administer it and the people who are called upon to obey it. In short, its success depends on the attitudes of all Americans, on their attitudes towards freedom, the stand they take against prejudice and discrimination. This Constitution 1992 is clear about the presumption of innocence until proven guilty. It says that even when you are charged and you are being investigated and you are being tried, rights accrue to you. But what do we see? The practice is almost as if, Samson, and you can speak to this better, that you are guilty until you prove your innocence. That's a practice in reality. By every conduct, by every deed
We've turned the law upside down.
That's civil law countries. It's the other way.
Yes.
You are guilty until you prove otherwise.
But
we are common law countries.
Absolutely. But that's not what we practice here. If that's what we want to do, we should go for that. But until then, let us be faithful to the law. Now, the statement that came from Eoco, for me, is betraying and exposing how poor they are working. Did they use the statement unknown, his travel outside the country was unknown to their office? Mm-hmm. Is it a security and intelligence office? Eoco, is it?
What do you want to say?
That they could not establish that the man was out when they were putting an alert at the airport, that he shouldn't be allowed to travel out.
They said they didn't know. Are they supposed to know?
And I'm saying for them not to know as a security and intelligence office is a problem.
Are you being fair to them?
I am. Look, there's supposed to be coordination among the security agencies. True? And when they put his name there, not to be allowed to travel, is it that they didn't have information that he had already left? I'm raising critical issues because you see, at the heart of this matter is not the person Aboagye Miracle. And I'm saying it is not about him because he's a partisan person. And when he was picked up, you saw how his party people went. The following day, they massed up there. And we've seen it in the past, that when party people are arrested, how their party people rally behind them. What about me, a non-partisan? Who will come to my rescue?
This bail condition we all complain about. If you got to know how poor people suffer at the hands of the police.
Yes.
They lock them up 1 week.
And
nobody cares.
That is my concern. That citizens who choose, and we are in the majority, not to belong to NDC or MPP, who in total, in terms of their membership, and I doubt it, will not be more than 4 million together. NDC is not up to 2 million membership. MPP is not up to 2 million membership. Even if you are taking the votes they accrue or they get after elections.
I thought each one of them would be up to about 4 million.
They are not. Check. Let them produce it to prove me wrong. I've been in that space before, you know. So, for me, that is the first concern. Then the issue that my sister raised about all of us, equality before the law. You see, at the end of the day, it was Justice Akufo-Addo who, in the Kulungungu bomb trial, said that the multiplicity of suspicions do not constitute guilt. You can suspect someone all you want.
That's State versus Kasina.
Yes.
Yeah, Ali Kasina.
Thank you. That no matter how much suspicion you have, no matter what, dislike or whatever.
They said a multitude of suspicions put together cannot constitute
proof of guilt. So, you are investigating, and it can be your theory that the person, based on the evidence you have gathered, may be guilty. Yet the law says that until the person is proven guilty by the court, he or she is not. And that should be the attitude of you, even the investigator. Then I want to talk about noise and thorough investigation, because the president mentioned it. We've read the works of some classic investigators or national security people like KB Quanson. Thorough investigations do not take noise or, this Rambo-style activities. The thoroughness of your investigations will have to be done in the quiet. By the time the person realizes you have exposed or got the person where they cannot, escape. And that for me is what we should be looking at. In conclusion, my belief is that if the gentleman, as he claims, was not asked or questioned about the amount Eoco is putting out. I'm sure he reserves the right to sue or even go at Eoco. Sometimes we need to encourage people to test the law against, state authorities. But if Eoco is also sure that he has improperly taken such an amount from the state, I will each any day support that the state goes after him. Yeah. But let's do it in measured manner. Let's do it according to law. Thank you.
Unfortunately, constituted authority like prosecutions, it's difficult to take up a defamation suit against them in law.
I'm not talking about defamation suit.
Okay, what else would he do?
I'm infringing on his rights.
Okay, human rights.
Yes, human rights.
Okay, yes, Dr. Sakrapo.
So, earlier this week, I was on PM Express. There was a lawyer on the show, and as we were talking about Mr. Aboagye's case, said, if you think about it beyond just a single individual, that there are systemic issues. And he talked about the fact that we only get to hear of persons like Mr. Aboagye because they are politically exposed. Yeah. But we have no idea
how many people,
the ordinary persons on a daily basis who have to deal with some of these systemic challenges, as for example, as it relates to how we treat suspects, how we deal with the issues of bail. So one of the things that I'm asking myself is if at some point there would be some merit to narrowing administrative discretion around these things by coming up with some guidelines, some specific ways of saying, in situation A, this is so that in the eyes of the public, fair and reasonable would not become subjective interpretations of what a state actor has done, that we can have some criteria we can all look at and say, oh, okay, we can see why this is acceptable or we can see why this is not acceptable. So there are those systemic issues that has to be dealt with. We also cannot remove the element of our partisan politics around this issue of presumption of innocence. I would always quote former President Akufo-Addo on this, where he says, not until you are in trouble with the law, you would not fully appreciate the importance of due process, right? But you tend to see the partisan element trying to convict people even before a court of competent jurisdiction has made pronouncements about allegations against them. And in saying that, state actors should not be seen to try to reinforce that denial of the presumption of innocence. Because if you read a Eoco statement that says, oh, we held Dennis because we have significant information and there's a 55 million CD.
Significant new information.
And then they put out 55 million CDs, right? And then a day or two, you see social media of an alleged property that belongs to him. What you create in the minds of persons who want to use that for mischief is to quickly make that connection and say, oh, probably this is the 55 million that Eoco is talking about.
That's what they are saying already.
Do you see what I'm saying?
And so he has had to now come to show that, look, I am not a man of straw. I didn't just come into politics to make money. I had businesses. I was running businesses from my days at University of Ghana, running a business when I was at Legon. And he says today, if you are eating sausage, perhaps you are eating from him because he's in that business big time. So now he has to justify to the public that the impression that I can't build a house or a house of this nature until and unless I stole from government is not correct.
And for me, state institutions must not be seen as trying to reinforce such narratives that do not grant citizens that presumption of innocence, right? Because the very citizens who are making such claims on social media, I bet you, should they run afoul of the law, would want the law to grant them those same due process rights, those same presumption of innocence.
But you are the Afrobarometer man. Afrobarometer has told us that corruption has been normalized. 8 out of 10 people say it has become normal, and they don't even want to report it for fear of retribution. So you say we have to be angry about it, otherwise nothing will work.
Yes.
So they are getting angry, oral, push.
And
name and shame them even before you prosecute.
We have to be angry, we have to demand accountability. But my point is that in doing all of that, you also cannot rob your fellow citizens of that which has been guaranteed to them by the Constitution, because should you find yourself in that same situation, you would want those same rights given to you and guaranteed to you. And as a state actor, I worry that your actions or inactions may reinforce that denial of your constitutional right to the presumption of innocence. So that is what, for me, I'm guarding, or I'm actually issuing.
Yeah, but the other thing people say is that we are quick to attack the institutions when they are the ones who did the investigations. They know better than us. The people who were demonstrating, what do they know about what has happened? You know,
Samson, I always say that the crisis of confidence that we face in institutions, right, again, as captured by Afrobarometer, low trust and all of those things, the burden to change that, I won't put it primarily on citizens. Yes, I don't agree when citizens attack institutions, when partisans attack institutions. I don't support any of all of that. But I think ultimately, to restore that confidence in institutions, the greater burden is on state actors, right? Through their actions or inactions. They carry the bigger burden of saying, you know, the way we go about things, the information we provide to the public, the transparency with which we do things, the ensuring that we protect people's due process rights. Those are the things that state actors would have to do over time before we can get back to a good place where enough citizens would begin to have greater trust in institutions.
All right. Thank you very much. My guests, you have been listening to Nana Ejay Bafo Ewa, Tom Theophilus Jemiga Jr., Victoria Bright, James Kwabena Bonfe Jr., John Osai Kwapong. We'll be right back.
In my line of work, a confident smile is everything. Kale Charcoal Toothpaste keeps me on top of my game and ensures my smile is always radiant and bright.
With the tiring nature of my job, we spend several hours under the scorching sun. To keep our teeth white and our breath fresh all the time, we use none other than Kale Charcoal Toothpaste. Kale Charcoal Toothpaste. You're on a Kessie and in a kit one.
Samayo Kendini, who be here, Semetra Sapapadia to Amame Manfo, Kale Charcoal's natural ingredients, and a bomb is several buying, and Maniswing, Nesasu Mama Hotoso, and will beg you.
Kale Charcoal Toothpaste. Choose Kale Charcoal Toothpaste for anti-cavity, whiter teeth, and fresher breath all day. Available in 80 gram and 150 gram. Grab yours today.
Kale. Happy Smile. This advert is FDA approved.
From the heart of Africa we stand, building dreams across the land. Every step we do your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. We go there for you night and day. Strong as a group, close as a a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as
Having gone to Translight Solar, really, it's been one wonderful experience. Since the system was installed in my house, my daytime could be somewhere around 20 cedis. And so I've seen a marked reduction in my bills. And because of that, I am not paying as much as I used to do when I was relying solely on the national grid. My house has now become the city on the hill. With this current doomsaw, anytime my area is off, my house is well lit. Everything is on point. And I can get as much as 13 to 14 hours with my ACs and everything working perfectly well. So I can say, as for Translight, they are the truth, the way, and the light. You have to speak to Translight today. In fact, speak to them now, right now.
Translight Solar. Translight Solar.
Discover Willow Lane in Sakumono, one of Ghana's most
Ready for a smile makeover? Hi, I'm Tanya from Bethel Dental Clinic, Ghana. Cosmetic dentistry services can enhance your smile's beauty and boost your confidence with a more attractive and radiant look. Whether you're interested in teeth whitening, veneers, or a complete smile transformation, an experienced dental team can help you achieve the smile of your dreams. The process begins with a consultation where we assess your oral health, discuss your specific concerns and goals to create a tailored treatment plan. While smile makeovers primarily focus on improving the appearance of the smile, they can also offer functional benefits such as better bite alignment, improved chewing ability, and enhanced overall health.
Healthy smile.
Palladium Residences in Achimota isn't just an address, it's the home you truly earned. Secure your place with just a 10% deposit and choose from beautifully designed modern apartments or spacious townhouses built for everyday comfort. This is more than a building. It's a vibrant, curated community with a clubhouse, state-of-the-art gym, and an on-site hotel, all at ABC Junction, minutes from Achimota Mall. Enjoy city energy while retreating to your private sanctuary. Call now to reserve your unit and benefit from limited launch incentives, including priority unit selection, executive pricing, and flexible payment options available. Don't miss the chance to pick the best homes. Book your private site visit today. Call 050-9823-424. Palladium Residences. Live smart, invest better.
Another week is here on the greatest of all time show. My name is Giovanni Clip, and tonight we're bringing you talent. Contestant number one, let's bring Eoco. Let's bring. He did it for you.
Cut. Oh, there is a leakage.
Where's the plumber? For quality and durability, insist on Syntex pipes.
If you want quality, this be where you belong.
Strong, tough, and reliable. Your perfect match to your trusted Syntex pipe. Syntex pipe, it dey carry water, no wahala. Syntex pipe, it dey make water dey flow. Syntex, and you're strong, and you're tough.
Yes, next. Hey, Nadia Benson.
Me didn't tum. Mr. Femi Kalika, just call me cockroach. Now, Mr. Femi once now. Hey, is that you? Impruka. Yeah. Captain Mosquito, double the action. Me didn't sasso spray. Mr. Femi sasso quell. Yeah, go to my sasso.
Sasso, come and tum preko.
Day by Day exists in lotion, cream, soap, and more. Day by Day has 4 fragrance range.
Welcome to Sulas Enterprise, the shop that deals in industrial machinery such as generators, rice millers, water pumps, compressors, and mowers. From the smallest to the largest capacity, at Sulas Enterprise, we give you nothing but the best from the best brands such as Honda and Perkins. When it comes to our generators, we also sell mowers coming from brands like Honda, Briggs, and Straton, and Oleoma. And when it comes to our water pumps, we offer you brands like Lily, Prudin, and Pedrolo water pumps. We also sell rice millers for all capacities. We are located at Spintex, Kakalika Plaza. Also, find our various locations as displayed on screen. Or call us on the following number: 0243-839-463 or 0554-154-416 or 0240-541-493.
Sulas Enterprise, where quality meets affordability.
From the heart of Africa we stand, building dreams across the land. Every step we dey your side, helping you rise, taking you higher.
Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. Strong as a group, close as a partner. Bank of Africa lifting you higher. African Bank with global reach. BOA make your future glow. BOA, we go there for you night and day. Strong as a group, close as a partner. Bank of Africa lifting you higher.
Bank of Africa, as strong as a group, as close as a partner.
Do you want a healthy smile?
Ready for a smile makeover? Hi, I'm Tanya from Bethel Dental Clinic, Ghana. Cosmetic dentistry services can enhance your smile's beauty and boost your confidence with a more attractive and radiant look. Whether you're interested in teeth whitening, veneers, or a complete smile transformation, an experienced dental team can help you achieve the smile of your dreams. The process begins with a consultation where we assess your oral health, discuss your specific concerns and goals to create a tailored treatment plan. While smile makeovers primarily focus on improving the appearance of the smile, they can also offer functional benefits such as better bite alignment, improved chewing ability, and enhanced overall health.
Healthy smile.
You're welcome back. This is Newsfile, it's the most authoritative news analysis platform, and here on Newsfile we put Ghana first. And those of you who have been talking about my shirts, it's from Habil's Couture. You can call them 0200 84 1988. 0200 84 1988. You get the best of kaftans from Habil's Couture. And the show is also brought to you by Bank of Africa, strong as a group and close as a partner. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. Syntex Tanks is strong, it's tough. Safari Valley Eco Park, bringing you closer to nature. Now let's go to Parliament, and we're going to be very brief on this subject, and so that we can canvass one other subject briefly before the show ends in the next less than 40 minutes. So the majority and the minority can't agree whether the governor of the Bank of Ghana should speak and take questions in the presence of the media. But why not? Listen to them.
That the ability to intervene on the market is as a result of the domestic gold purchase program. And that what they are doing is that they are mobilizing forex proceeds from the domestic gold purchase program, and those are the forex proceeds that they are using for market intermediation. Why is it that the majority is preventing the governor from saying this to the entire country? Is it because he's of the view that it undermines the stories they've been telling the people of Ghana, that it is because of the gold board and some new strategies that they have brought? Is it because the governor is here to admit on record that it is as a result of the domestic gold purchase program that they are able to mobilize these forex resources and inject onto the market? Is it because they are afraid that if that is said, it will become glaringly clear that the person responsible for this is Dr. Mahmoud Bawumia? Is that the reason for which they are clearing the media from the gallery?
Exactly.
So that they will continue to peddle the story to the Ghanaian public that is because of gold board and some superior strategies that they have introduced. Because the governor is here to admit, and he even gives the dates on which it started and the steps that they are taking to continue with it. We have further questions on extra losses that the central bank is incurring. You recall that recently, when the Bank of Ghana accounts came, instead of complying with the act to lay it before Parliament, they have still not done it. They invited you here, and they invited NDC party members and members of NDC caucus to come and announce an understated loss to you here. The finance minister has still not presented it to Parliament. We are observing more losses that are happening there, and they know the governor will be requested to answer, and he cannot lie. And so they are denying you an opportunity to cover the answers that he will be given.
And we'll ask you to read Table 6. It will come out clearly that the gross reserves as at the end of the first quarter was $14.2 billion. Information to us is that, gathered by the caucus, is that as at the end of June 2026, this has dropped to $12 billion. We want to find out from the governor, or we're asking him to confirm whether he used the $2 billion for market interventions. That's a simple question we want to put to the governor.
Order 266, that meetings of committees, and the committee of the whole is also a meeting of the committee. So it says that proceedings of a committee shall be held in public except otherwise determined by the committee. So I asked them to convince the entire committee to want to sit in public. But if you don't convince the entire committee to agree to sit in public, you cannot force the committee to sit in public. And they walked away. They couldn't convince the committee to sit in public, and rather opted to walk out and abandoned the question.
The penchant for not dealing with the substantive matters on the floor, and going on a tangent just to produce sound bites. And those sound bites, we see them on TikTok. And people who are listening and watching on TikTok, they don't even understand the circumstances under which those comments were made and whether they were ruled out or not. So if you open the gate for media to be there, Afenyo will not be addressing the issues we are discussing today with the governor. He will get up and speak about every subject under the sun. And that is what you will capture, and that will appear to be the conversation that have happened. It is the reason he must be controlled. If he's not willing to play by the rules and stick to the matters that we are discussing, we will not allow him to stray into other extraneous matters.
Dr. Saiko, is the public being shortchanged by this development?
My opinion, and with respect to the majority side in Parliament, yes. I've always said that we seem to have this culture of the less the public knows, the better, right? I mean, and sometimes it's on things that have no consequence for, let's say, state security, national security, things like that. I know that the majority that did mention...
Hey, this one may have consequences. You can't pay the day.
But, I mean, Samson, what would the governor of the central bank say, right? Or, whatever questions and answers he'll be providing, right? That, God forbid, the media report said that it might crash the system, or
why the gross reserves have dwindled.
Do you see what I'm saying?
By 2 billion, as they say.
But for me, it goes back to what I have observed, that generally we tend to have this administrative culture of less information is better, or it's not everything that we want the public to know. I mean, I recall years back during my dissertation, it was a very simple report I wanted from a public agency, some of which was online. They just didn't have the most recent 3 years online. And I went asking for it, and you should have seen the reaction of the bureaucrat, like, what do you want this for? What are you going to use it for? And I'm thinking, I'm not asking for a state secret. Yes, the majority leader says he reads the law or the rules that says, unless otherwise determined, and if you could not convince us, then, we can't go down that route. I always say that, look, if we subject everything to a legal test, right, as opposed to the appearance test. Yes, the legal test, you can simply say, check, you couldn't convince us, the committee will stay. But how does it appear, right? You're trying to, for me, create a culture of greater transparency. And so, even though you are saying the committee couldn't be convinced, and the honorable minority leader may subject it to other things, leave that up to, the media.
Well, I think that was extraneous, really, because it's not the minority leader who was asking questions.
Right.
It was Nkrumah who had questions.
So, for me, again, the bottom line for me is that it really boils down to more transparency, more information. For me, is always better than trying to find reasons why a public official cannot be heard speaking publicly. I mean, can you imagine the U.S. where the Federal Reserve Chairman goes before Congress, and you have, yes, they might disagree, both partisans might have all kinds of questions for him or her, but you're used to seeing public officials being questioned publicly over and over again. So I don't get...
Vicky, what do you say?
I think that for me, the test should not be really what is politically convenient for the majority or the minority. That should not be the test. The test for me should be whether there's a specific and demonstrable risk to financial stability, market integrity, commercial confidentiality, or something else that will outweigh the public's right to know. Pure and simple. That should be the only thing. If yes, then the affected portion may be confidential, as opposed to a blanket, ban. And if no, then the discussion should go ahead and be public. So I don't know, because these are questions that were raised Kojo, and the answers were already, or at least the preliminary responses were already on the order paper anyway.
That's right.
So unless they were gonna delve into follow-up questions that maybe move into
yes, that was
like,
expected.
Yes, currency reserve management strategies by the central bank, market timing, or anything that's genuinely market sensitive. It's difficult to see how it can be justified. I mean, we all accept that there are situations where proceedings have to be held in camera for all sorts of reasons. And I just think that, I think for me, what I would have preferred would be for the House to first determine which parts of the proceedings were confidential, and the legal basis, to explain the legal basis for that confidentiality, or whether it's some kind of standing order or whatever, and whether we would then subsequently get a public transcript or some kind of summary afterwards. That's what I would have done. And I just really wished that I can understand the opposition's reluctance to participate, because that may have been interpreted as them, being okay with it. But I wish that they had stayed and participated under protest, and then maybe challenged the decision formally afterwards. We just need, all these things we keep talking about, one recurring theme keeps coming up: just tread with caution, tread with caution, tread with caution, because we need to be careful that little by little we don't chip away at our rights as a people. And when you look at these things in silos, some of them may seem okay or not so serious, but when you put everything together and look at it as a whole, if we don't take care, we may end up chipping away.
Right.
And we don't want to go back there.
Teofilo, so like Vicky said, the answers have already been given. They are on the paper. They are now just going to go through the process of repeating the question and the answers. Why is the, gross reserve reduced by so much? Why? What do you have to hide about the interventions you are making in the market, forex market, and so on? So why deny the Ghanaian public access to that live?
Let me use your platform to appeal to my brother here, the MP for Menchia. Is it Menchia South?
Menchia South.
Menchia South. That the idea of walking out always is a bit detrimental sometimes. They are elected to represent the people, and the MPs have their own assemblies back home. And if there is something that he feels that Ghanaians need to know, he is their representative. He will sit in, hear the thing, and communicate to his people. That is simple. So I do not understand why they will walk out, and you walk out, went to the press, and justify the very reason why the majority is saying, this is what you want to do. Then if we take our brother Kojo Nkrumah's honorable's position, for example, you're talking about the benefits, yet days back you were not willing to accept the disadvantages of the same system attributed to Vice President Mahmoud Bawumia. You see, this central bank has been a bit transparent. The MPC publishes their decisions to everybody. We say it, they come up with accountability, etc.
They hold live sessions.
Yes. So I agree with my sister here who says that.
So why not do it live in Parliament anyway?
No, if the risk, financial risk, outweighs the public's ability or the public's view to know what happens, then let us look at it. Sometimes it is not everything you put up. Years back, I was in Europe, and somebody was reading about Ghana and says, there are pickpockets in every country, but you go to Ghana web and they put it there, when you come to Accra, beware of pickpockets. And that has affected the person's thought about coming to Ghana. And indeed, there are pickpockets everywhere. So, in effect, I would disagree with Prof here. Even in I think the Sunshine Clause or something, Congress is briefed in camera. They don't brief Congress every time in public. And even the Bank of England also does not always brief in public. So I will appeal to them again that this, apart from us trying to get political capital out of this, sometimes let's look at what we are going to do to the country to prevent panic, prevent leakage of sensitive information. Remember if somebody talks now and it appears like we don't have money, people will begin to run to their banks to withdraw and there will be total collapse and meltdown. Some of those things need to be prevented. And I think that you also have very good persons on the financial and economic committees. You can equally call back the Bank of Ghana governor to such a committee meeting and elicit information.
Succinct in 2 minutes. Yeah, Nana? So why? The thing is already, you know the answers they have been giving. So why do you want the media to cover it?
In the same token, the other paper that contained the answer is a public document, and the media can take hold of it. And so if the answers were already on public documents, then
what's the point of the boycott?
The point of what's the point of not allowing the media to be there? You see, my brother just made an appeal to me. I ought to also make an appeal to my friends in the majority, the NDC. They seem to be suffering from the curse of majority in parliament. That curse makes you think that you can do anything, even change a man into woman or woman into man, right? Because you think that you have the power. And that is what the NDC is suffering from. And that curse is making them perpetuate the status quo and forgetting about the reset that they promised Ghanaians. When we first came into parliament, or not long after we came into parliament, they summoned the governor of the Bank of Ghana to come to parliament and answer questions in respect of the Bank of Ghana building. They wanted to know about pricing. They wanted to know about the scope of the contract.
That was Mahama Ayariga, right?
That was Mahama Ayariga. And he insisted that it should be covered live to Ghanaians, because he thought that he was going to expose the previous government about some corrupt dealing. And when the Bank of Ghana governor came, they had X on their faces because their expectations had been disappointed. He actually came to confirm the transparency with which the whole contract was executed. And so if you had already set the precedent of having a televised committee of the whole meeting of the Bank of Ghana, why then do you deny the minority the request that a question?
Two different situations.
But it was.
You are asking about bank building. Here you are asking about reserve. You are asking about exchange interventions.
And the answers had already been provided for. And the answers were on a public document. And so therefore, there was no secrecy to which the necessity to hold the hearing in camera, right, arose. And so when they say that it should be in camera, or there was a justified reason for it to be in camera, the basis was not there. The basis was not there. And you see, I watched my senior brother, Adongo, right, saying certain things about the minority leader. And I felt sad. He had forgotten where he was. Not long ago, he was in opposition, he was in minority. And he had promised Ghanaians that they were going to do things in a different manner. But I realized that he was also caught up in the deception that politics in this country, or governance, is between the MPP and the NDC. And so when he's addressing Ghanaians as though he's addressing the NDC. We only stand in the gap for the people of this country.
Right.
And so when we are addressing them, we shouldn't make it seem as though we are reduced into a match between the MPP and NDC. What we are asking for, we ask for and on behalf of Ghanaians, and they should be addressed accordingly.
Should they be boycotting over this matters? Do you think it was necessary? It's already been provided, except you want cameras to capture, the intonation of what has happened.
Precisely so. You see, first of all, I want to say that when it comes to issues of the central bank, the credibility of the central bank is a national security issue. Information from the central bank is national security. Now, there's a dilemma and there's a contest that will always be there between, in this case, the minority being obsessed with vindication, as their press conference said, and the majority being apprehensive about transparency, as they are afraid of in terms of what they also put out. The issue is, how do we navigate and reconcile the two? I think that sometimes, in this particular matter, the boycott was unnecessary by the minority. And my brother just advanced the argument that Parliament is a house of records. True. And the information that you had requested had been provided in the order paper. Is that correct?
Yeah.
So you have it. And if it is about letting the press know, you can hold a press conference and read it out. Nothing stops you. But follow-up questions in such an engagement has the potential to affect our investor community and communication and so on and so forth. And whether we like it or not, this regime has done well in terms of stabilizing our currency against the major currencies. It's a plus. As to how they have done it and how they are doing it, there's no denial now that the gold for oil program that the former vice president actually suggested or instituted is having some influence on what we are doing now. In fact, the setting up of the gold board as an entity, which is also doing well now.
Domestic gold purchase.
Yes, must definitely have taken some inspiration from the gold for oil thing. So rather than, and this is my advice or suggestion to Parliament, both majority and minority, rather than this constant engagement over a battle of what I call obsession with vindication on the part of the minority and apprehension with transparency, let's meet at middle ground and see that you are representing us, the people, and do a win-win situation. It is for Ghana.
Let me bring you on a different matter, and the show is brought to you by Waylead, your trusted home builder, Bethel Dental, the Smile Stars here, Kel Charcoal Toothpaste, Happy Smile, and Palladium Residences. Live smart, invest better. Safari Valley Eco Park, bringing you closer to nature. Now, listen to the Lands Minister.
Ladies and gentlemen, I have a very important news in the forestry sector as well. I'm happy to announce a historic cabinet decision taken on the 24th of June 2026 to revoke Executive Instrument EI 144 as amended by EI 234, effectively ensuring that the Achimota Forest retains its original status as a forest reserve and providing ecological safety zone for Accra and its environments. And you have to clap for that. If you think about it, this is the only last man standing forest cover in Accra, and President Mahama is determined to protect it at all costs. Achimota Forest, the EI has been revoked, and what it means is that all of those areas are part of it. I won't go into those who have willed it. I believe that is a matter they can deal with. But what I know is that President Mahama believes that the people of Ghana deserve an environment that will keep us all alive, and that's why he's protecting the Achimota Forest. So we are making progress. We now move to the National Anti-Illegal Mining Operational Secretariat, NIMOS. Ladies and gentlemen, the fight against illegal mining remains one of the ministry's highest priorities. During the period under review, NIMOS sustained nationwide operational tempo against illegal mining across 6 endemic regions, namely Ashanti, Western North, Eastern, Bono, Ahafo, and Central. A total of 200 operations were executed across 53 districts, recording an operational strike rate of over 84%. I think we can appear in steam. the Secretariat conducted 169 enforcement operations targeting illegal mining sites, forest reserve, river bodies, and concession encroachments.
Good news, Dr. Bonfe.
It's good news if it is done. And I say if it is done, I have no reason to doubt my brother
Aboagye.
But we have seen over time how persons entrusted with state power and authority, rather than protecting state property, acquire on the backside of or on the blind side of everybody else these things to themselves. If you all over, and it is not limited to any regime. Me, if you give me state land for free, I will reject it. I don't want it. It's a principle I live by. But tell me how many ministers and former ministers of state who are occupying, as we speak presently, lands that only a few years back were designated state lands. We need to be sincere with our commitment to public service. Samson, and I want to say this, many and most of our problems persist because some people profit from them. But for that, we are great people. And so I just want to say that, look, in the mindset and the thought and the attitude of trying to make Ghana work for all Ghanaians, let us decouple the political capital from Accra. Let the commercial capital retain or remain here. Take the political outside. I'm not campaigning for Kintampo because I come from there, but the central part of Ghana.
That's right. It has been said over and again.
Yes, I'm not the only one saying it.
Right.
And you have enough land advanced.
That's right.
That we can give for this purpose gradually. And I heard the president talk about it.
Right.
Into 10 or 20 years. Mr. President, let's start working towards it.
Thank you. Theophilus, so and NIMOS to striking rate, and then the people are asking all of these, plenty talk. We want to see the real action, as in reformation of our water bodies and everything else.
Oh, I didn't talk about the.
It's okay. Let's move on. Yeah.
I think lots of work is being done. I think it behoves on maybe if we had juxtaposed it with the latest report from Erastus, then maybe we would have said that, oh, they are just talking, they are not working. So I'll leave that for you to juxtapose from Erastus. But on the Achimota Forest, I think it's one of the best news we have heard for a long time. In John Dramani Mahama 1 administration, they brought up a proposal to have an eco park, no concrete, flooring, etc. And there was also the idea from the civil societies working in that sector that the original OWU families had been paid. In any case, if they were not paid, once there was an LI, it has changed hands, they should move on and we should all move on. If you fly across Accra, it's the only greenery you can see.
Yeah.
So I think it is good news for it to be brought back. And I want to plead with current politicians, future politicians, at least, let's leave that one. Let's go look for land somewhere. As he said, maybe if we go to Kintampo and start Kintampo, that place will become the new East Legon of Ghana.
Right. Thank you. Vicky.
It's very welcome. I want to commend government for doing this. The forest is an important ecological asset for Accra, providing us with flood protection, urban cooling, and biodiversity, and a significant public green space. So for me, both symbolically and environmentally is significant. And I think, kudos to the president and his team for doing this. We need to follow this up by the legal and practical actions which are required to control the liberation of the forest, if you like. We need to see the revoking instrument, confirm the exact boundaries that have been restored, disclose the leases or private interests, the third-party interests.
Should disclose them?
Well, yeah. And because it's now a public space. So we need to know if someone is occupying it, we need to know who's there, right? And
if they are going to move away quietly, why do you want to disclose?
Oh, if they want to move away quietly, then
if they put it in their will and it comes out, that one we'll talk about.
So that and
right.
just 2 seconds on this Galamsey thing. As long as the politically connected financiers remain protected, as long as excavators are still allowed to enter forest reserves without detection, and district officials certify or ignore illegal operations, and the traditional and local authorities facilitate access, and as security personnel receive payments, and the prosecutions focus on the victims, the people who are working there, they themselves are victims,
Right.
while the financiers escape in their lofty lifestyles. And then as seized equipment disappear or is returned secretly back to them, it will continue.
Nana?
I'm happy the NDC has had a road to Damascus moment because the processes to rezone the place commenced under President Mohammed's first term, and that now he thinks that we should halt it and make sure it remains what it is. And so I commend them for having a road to Damascus moment. 2, I also agree with Kabila. All these things have come as a result of personal interest of some politicians. And to the extent that at some point we even heard that an outgoing president was interested in keeping an official bungalow. That should tell you the kinds of people we have become. A broken down value system, which is making our democracy very wobbly. You see, when your values break down, it makes democracy very, very unsustainable. And think we should start having that conversation that state assets are state assets. We should not, on the basis of our personal interest, want to convert it into a private property so that we can have a part of it. I think that in that regard, I'm very happy that, as I said, they have had a road to Damascus moment. Thank you.
Yes, Prof.
You know, on the Galamsey thing, good efforts. I mean, we've been having conversations about the challenges with Galamsey. Ultimately, though, like you said, citizens would also want to see some visible policy outcomes. The cleaner waters, the non-presence of Galamseyers in some of those places. On the Achimota Forest one, my only question is, how does this new move reconcile with the past, right? Does it make the past acquisitions that we read about in the news void? And how does the state deal with all of that? That's the only question.
Yeah, definitely everything else goes back to, the status.
Okay.
Right. But as Vicky was suggesting, you agree with that? There should be sunshine. All those who made the acquisitions quietly, we should begin to know before they die.
Yes. I beg you.
In case they will them.
The biggest problem with the persistence of illegal money in this country and why the fight is difficult for us is the continuous legal regime on ownership, where the state owns everything and the people who own the land and sit on the land earn nothing. Let's change that structure.
Yeah. All right. I agree with you. So that they'll be responsible.
Yes, the people own it, and so they will fight anyone.
All right, thank you very much.
Responsibility.
Thank you.
Anna J. Bafo, Vice Chair, Subsidiary Legislation Committee and Member, Constitutional and Legal Affairs Committee of Parliament. Theophilos Jomega, Junior Lawyer, Engineer, Member, National Communications Team of the NDC. Victoria Bright is International Corporate Lawyer and Entrepreneur. James Kwabna Bonfe Jr., CEO, Census and Lecturer, UPSA. Dr. John Osai Kwapong, Director, Quality Assurance and Institutional Effectiveness at Ashesi University and Fellow with the Ghana Center for Democracy, Democratic Development, CDD. Have a good afternoon. I'm Samson Ladi Anyanini.
Welcome to a place where everyday living is reimagined, where space, movement, and community come together effortlessly. With thoughtfully designed spaces, modern facilities, and everything you need within reach, you don't just live here, you feel safe, comfortable, and at ease. Step inside Eden Heights.